It's not appearing. Can you দিদি এটা তো আমি তো আপডেট করতে বলেছিলাম কালকে যেটা বলা আছে সেটা তো দিয়ে দেবেন কালকে কালকে তো আবার এটা আপডেট করলে কোনো অসুবিধা হবে না কারণ ওখানে আনঅথরাইজড ডকুমেন্ট আগে নেওয়া হবে বলে দিই যখন সেটা তো করবেন আমাকে জিজ্ঞেস করে নেবেন নিজে থেকে ডিসিশন নেবেন না What is your item number?
671. Student list. Yesterday's list 644.
Let us see, tomorrow we shall take up from 650. If it doesn't reach tomorrow, please mention. Yes.
But mention these two items are connected matters arising from the same fact. In one, they are refusing me refund, and in another case which has been filed, they are demanding the same money by exercising section 74. So, and they are now pursuing for demand, recover the demand. So this এটা লিস্ট থেকে আগস্ট মাসে ছিল ওখানে লেখা আছে and then it has gone out of list, and this is one cancellation matter. This is appearing in today's list 614.
It will appear in the upgraded motions.
Much of that
may not be tomorrow, maybe
I have just time to mention this matter was covered match 2014-15. The 140E proceedings were covered by RT marketing, the court bench. Covered matter, it's running in the list below as item 549. If it can be taken as we mentioned, it can be disposed of.
549.
549 of today's list. We have given notice to the other side, Mr. Arjun Dutta is appearing. I'll inform him personally also. The matter is listed, but I'll inform him immediately.
Very well, we shall upgrade it. 549 tak kono din upgrade kore diben.
With your lordship's leave, I was mentioning for inclusion of a new motion matter, my lord. This is with respect to unauthorized
New
occupants.
motion, you please give it, will appear.
May I be permitted to mention another hearing matter for inclusion in the list of the
Which year?
2023. That's been lastly
23
hard by
I don't have determination. 23 I don't have determination. Which group?
Group 6, my lord.
I don't have determination.
But you may mention serial 548. Here the writ was filed in 2024, 16 July 2024. It was regarding
এটা বন্ধ করে দিন আবার আসছে
it was regarding an advance ruling authority's order wherein the ruling was against me, and then the appellate authority of advance ruling, the members gave a divergent views. So now we came before the writ court, and it was regarding the classification of a product Jack olive oil. Now, Lordship, because this is pending, in the meantime, department is proceeding with assessment of all the years, classifying my product as a cosmetic instead of a Ayurvedic medicament. And the demands of crores are being confirmed. And the members of the AAAR differed in their views. The members CGST answered in my favor, and member state answered in revenue's favor. So by the efflux of law, Lordship, the advance ruling authority also got nullified. Now, in such a situation, Lordship, they are referring to this. And recently, in another matter, the advance ruling authority has classified similar products as Ayurvedic.
give it
She may have a comment to mention
দিদি
one
এটা বন্ধ
matter for
করে দিন জানলা এটা খুলে রাখেন কেন ঠান্ডা লাগে শুধু
She may have a comment to mention one matter for inclusion in the writ of 2019, my lordship.
2019 what hearing matter
Yes, my lordship.
give it will appear please
Maybe you lost time. Two item 336 and 337. This relates to cancellation of my GST certificate.
yes give it
But I have served notice to the other side.
please write the grounds of urgency because at the time of going through the slips if it is not there it may not appear as urgent
Then I am writing.
please write it
I will give it to your lordship.
because it will not be possible for me to remember the face and the item so I'll go through the
item number 49 of today's call is not related country matter. Right?
49.
Item number 49. My lord, on last day indicated that it would appear under the urgent matter. Order in name. But my lord, it indicated.
Very well, it will appear. It will appear as an urgent motion.
May I please your lordship?
Any grounds?
No, I've just written the.
No, write it. Otherwise, it will again go out.
My lord, may I be permitted to mention three identical matters, my lord, for upgradation. The reason is, my lord, the entire business operation is closed under verbal direction of the respondent authority since 1st September, my lord. The entire business operation is closed since 1st September, my lord, 2025. Under the verbal direction. They came for a such and seizure. On that day, they directed not to operate the business, and that is following
Give
treatment.
it.
The three matters, my lord, single.
Very permitted to mention one matter. My lordship, one restriction has been prepared under group one. My lordship, that act.
Group 1, I don't have.
No, my lordship, act is that West Bengal public land eviction of unauthorized occupiers act, my lordship. But the matter wrongfully came to the list under group 4, my lordship. This is the first day of hearing, my lordship, and it is categorically wrongly entered to the list, my lordship. If you kindly allow, then it will be corrected, my lordship.
I couldn't get you. It is appearing in the list under the group
Yes, my
4.
lordship, under group 4, my lordship.
It's an unauthorized occupants matter.
Yes, my lordship.
Which matter you indicated to the court officer, it will be taken care of. It will go in under that heading. Extension of entry order, please.
Your Lordship, if I kindly be allowed to mention a matter at serial number 574, it was mentioned yesterday by my learned friend Rishi Raju, Lordship. In this case, the next date of hearing we are challenging show cause notice. The next date of which has been, the final date has been given.
Very
of
well. Why are you
hearing.
mentioning it today? I told him yesterday that it may not appear today. It will appear on some day, not today itself. Not mention every day.
Much.
Only
Don't expect the matter to be listed immediately after the day you mention, because there are others who have mentioned prior to you.
Got it. Much.
only inclusion in the list, my lord. Listed person, my lord.
May I be permitted to mention, my lord, item number 38 of today's list, and 35, my lord, don't stop that. My lord, what happened yesterday, my lord, this matter was appearing as item number 25. 28, 24, up till 24, the matter was taken up. Right. Today, somehow, my lord, the item number is.
So it will go down because of the seriality. Why are you mentioning like that? Yes. Please don't mention unnecessary.
My
May I please your lordship?
For a prior period after my resolution plan was approved by XAS, your Lordship. Your Lordship, this issue has been decided by your Lordship by already did 12th of November, decided the 27722 of 24, your Lordship. Your Lordship is kindly, your Lordship is a covered matter, your Lordship is kindly.
I'll take it on some day. I'll indicate. I'll take it.
Great.
Didi,
Liberty to mention two matters, my lord.
just a minute. ये डॉक्टर काल के mention है चलो.
May I please your lordship?
Please wait. Yes.
Liberty to mention two matters, my lord, for upgradation. In one of the matter, my lord, my demand order has been passed in violation of section 75, subsection 7, my lord. This has been, this matter has already been covered by another judgment of this Honorable High Court, my lord. My lord, may kindly upgrade this matter.
What is the matter?
My demand order has been passed in violation of section 75, subsection 7.
Very well. You wait. The recovery proceedings have been initiated, not yet.
No, ma'am.
We'll take it up. दिए दें? दे दें. Yes.
May I permit to mention one matter, my lord, pertains to public premises eviction of unauthorized occupants act, my lord. It was inadvertently filed before the residuary bench, my lord. That bench, honorable bench, has released the matter for want of.
It will appear in the list under the appropriate heading.
Yes.
Lordship, I'm mentioning for withdrawal, the party wants to go for amnesty scheme.
You have your instructions. Keep it with you. Which matter?
Lordship,
It's appearing in the list. No.
no, Lordship.
This for withdrawal to be mentioned for withdrawal. You bring your instructions in writing so that I can take it on record. Call to.
May I please, your lordship?
Yes,
Item number 563, your lordship, in today's list. The matter may be taken, your lordship. There is a recovery proceedings by the department, your lordship.
563
Yes, your lordship. New motion for group 4 matter, your
with the
lordship.
mentioning slip, with the mentioning the grounds of urgency.
Obliged, your lordship. Any date convenient, your lordships.
It will appear as under the heading urgent matters. Yes.
Obliged, your lordship.
Another matter for upgradation, my lord, this matter is also covered by the Honorable Division Bench of this Honorable High Court only. It pertains to refund rejection order being passed beyond a period of 60 days.
It can wait. It can wait. Yes, call this.
Lordship, item number 1 for the correction, Lordship.
Lord, I am for the respondent. May I be allowed to appear virtually, my lord?
তো এখানে অর্ডার দিয়ে গেছিল, অর্ডারের কপি এখানে রাখছিল, আমার সঙ্গে কথা হলো আলট্রাটেক নিয়ে। সে হোক, ওই ব্যাপারটা আপনি কথা বললেন যে আপনি অ্যাপিয়ার করেছেন রিলিজের জন্য, সেটা আবার দেবেন না? Yes,
Lordship, for the correction, Lordship, page 2, Lordship, para 5.
page 2, paragraph 5. Yes,
Yes, sir. The said letter dated October 28, Lordship, 2025. It will be October 8, Lordship,
not 28.
not 28. Lordship, one more, page 1, Lordship. Name of the petitioner, Lordship, the advocate is Mr. Shulokna Mukherjee. It will be Miss Shulokna.
These two.
Yes, Lordship.
Yeah.
Great.
This matter has been mentioned for correction of certain typographical errors that have crept in the order dated January 8, 2026. Full stop. The mistakes indicated are formal. Full stop. The order dated October 8, 2026 shall stand corrected as follows. 1. The name of the learned advocate representing one of the learned advocates, name of one of the learned advocates representing the petitioners, which has been typed as, within inverted comma, Mr. Shulokna Mukherjee, inverted comma closed, shall be replaced by MS Shulokna Mukherjee. ঠিক আছে? 2. At page 2 of the order dated October 1, January 8, 2026, comma, in paragraph 5, in the first line of paragraph 5, in the first line of paragraph 5 thereof, comma, the date, within inverted comma, October 28, comma, 2025, inverted comma closed, shall be replaced by October 08, comma, 2025.
Grateful.
That's
Yes, grateful.
the other portion of the order shall remain unaltered.
Much obliged.
Grateful.
You are appearing?
Yes, madam, I'm happy on behalf of the respondent.
We have a look paragraph 1, 4 and 5th line of that paragraph. My lord, representations are made by the petitioner to the said authority on February 1st, 2023. It will be 7th February 2023. Kindly have a look, page number 20 of my read petition. Bearing date 7th February 2023. Page number 20, annexed at P2.
Very good.
That's all, my lord. Kindly.
My lord is appearing on behalf of the Union of India. Kindly.
Identical matters. They are asking for Prime Minister's relief fund
Why
aid,
are they not appearing? Nobody is
but
appearing.
nobody is appearing since the day one. And
Lordship, I'm appearing online, my lord. Item number 4 and 5.
Yes. You were
Yes, my
supposed
lord.
to
Item
add.
number 4 and 5, I beg to appear on behalf of the petitioners. Your lordship would remember this was the matter regarding the acid attack and for compensation of 1 lakh. Now, my
Yes.
lord, there has been certain progress in this particular matter. I have received a call from the union's office asking for my account number. So if Milord kindly gives some particular time period to take proper instructions from my client that whether the amount has been disbursed or
Why
not.
have you not carried out the instructions in the order dated November 21, 2025? You are directed to add the State Legal Services Authority and National Legal Services Authority as parties to the writ petition.
Yes, sir,
You have
lordship,
not
I
carried out the
apologize.
addition as yet. Why?
Milord, I apologize for that. I was yet to take instructions from the client, and also she had told
No,
that he had received the call.
carrying out the order of the court will not await the instructions of the client. No instructions is required. This was an order of the court for you to add parties.
I apologize sincerely for your lordship. If your lordship kindly grants 14 days time, I will be abiding by that particular order, your lordship.
For correction, for carrying out the amendment in the cost title, you need 14 days.
No, no, that I can do within a week also.
Within a week?
Yes, sir, lordship.
That should be done on the same day, sir. That is how we have learnt.
Milord, I
An
will be doing.
amendment is prayed for on behalf of the petitioner. Full stop. It is noticed that the directions contained in the order dated November 21, 2025 have not yet been complied with. Full stop. List this matter once again under the same heading. Should I put it under the same heading or in a different heading?
Milord, in a different heading.
Not for dismissal.
No, your lordship.
Under the same heading, Kitty. List this matter once again. On January 30, 2026.
I'm deeply obliged, your lordship.
Under the specially assigned matters heading, normal heading heading
Deeply obliged.
4 and 5 দুটোতেই same order.
Respondent number 3 only. Union of India.
And, where is Mr. Bhattacharya?
Perhaps online, my lord. Perhaps because
online.
that was informed to us.
Online কেউ আছেন? আচ্ছা। Can you contact him?
Just we contacted him, called him, and he said he is
Tell him he is not online.
not online.
Chalo, I'm passing it over. Next.
Number 7.
7-8 is for the submission of compilation. Is for the compilation. I'm calling. But see, I prepared two compilations. One is on 74 and the predetermination, and another is on the issue of cancellation. All these judgments are part of writ also, Lordship, but your Lordship indicated to make a. So I've shared one copy with my soft copy.
But only this one, just one, I missed this one set. Yes. I take one. But one of his point was that this cannot be a case of 74. There is no suppression. Maximum, whatever, there is no fraud stuff. According to this point, they had taken in the, remember there was a previous petition where the show cause notice was quashed because we did not consider his report. And that was the background. Now we have considered, now he has come with a case that it's a prejudge. We have prejudged the intent. This was the background of the fact.
এই ইনার লোডটা কোথায় প্রণয় বাবু?
They are on the previous occasion, my lord.
Previous writ petition, the point was taken.
Yes, my lord, kindly see, this is his previous petition. The 41, 41. But this was the ground, also 74 ground was taken. That's why I have brought the previous. Kindly see. So, my lord, this issue that it cannot agitate this issue in this.
Very good.
Lordship, my reply to this would be the division bench order at page 74 had correctly recorded what was the pleadings and why it was remanded to the proper officer. Para number 22, 23 of the division bench order makes it clear, in 23 division bench records we make it clear that we have not rendered any finding on merits, and it is for the adjudicating authority, namely the deputy commissioner, to make a fresh decision in the matter after the additional replies filed by the appellant to the show cause. And the observations of the learned single judge, everything was set aside, and division bench recorded the findings at para 22. This exercise appears not to have been done by the authority, and therefore we are of the view that the matter has to be re-adjudicated by taking note of all the factual issues bearing in mind the legal principles laid down. So in my first writ, because the reply was not considered, and in the reply the point of 74 was itself taken. Now the division bench notes in everything into account and says the proper officer has not applied his mind, so proper officer has to re-adjudicate. And therefore, there is no bar on me. The division bench has made it clear that the bench has not gone into any merits. That is my reply to my learned friend's submission.
Very good. Since there are a lot of judgments, lot of papers now.
So from my side, it is only this one and my written notes which I had shared. There is no more. Now, Lordship need not rely on anything else.
That is enough. So I'll keep it one more day.
Lotships.
If I have any query on that,
Lotships.
On that day, either I will conclude or I'll dictate.
Whatever.
Lotships. As per your Lordship.
But not on Monday. On Monday, I have some difficulty.
Any day, as per your Lordships and my learned friend coming.
We can have it in the week beginning 26, 27. Compilation of judgments filed by Mr.
Whatever the.
That will.
No, that I have seen.
remain
That is
consistent
the
with
that
the-
is the only solace which I am having, my lords. That is the only solace which I am having from my other side. Ki only at least something I can get.
No,
That
he's very fair.
he is always.
He's very fair.
That is what.
And you are also fair. Both sides are fair, and it is pleasure to hear when
It is
both
our
sides are like
our
that.
pleasure to argue.
Because given this dumb bench, unless the
My lord, I don't have.
Lordship, the questions, the type of question is coming from that side. That is enlightening us also to be prepared before we argue before your lords.
no.
In the at least for the law side.
That is because of lack of knowledge.
No. Grateful.
Yes.
Well, all these are connected matters.
Yes.
And last
Yes,
occasion
Mr.
on
Bhattacharya, very
17th
easy.
December.
You were supposed to file a report.
Yes, Lordship.
Yes, Mr. Honjo. There was a report.
Yesterday, I have received the report, not in the form of affidavit though, but I have gone through the report. My lord's specific query was with regarding to the 6(2)B issue, since that issue has already been adjudicated or covered by the Shokaj notice issued by the state GST authority. Now, in the report, my lord, there is no such specific reflection. I have again intimated the department to give the specific
How
reply.
much more time you need?
My lord, kindly make it not this week, my lord.
1 week.
1 week, my lord, required, my lord.
26, after 26, Lordship.
Very.
After
রিপোর্টটা
26.
কোথায় গেল? কাগজগুলো তোমাকে দিয়েছিল?
Very well. I'm fixing it on 26th then.
Dot-
27.
27?
27.
1 or 28. I'm good
Yes,
to outside.
Take.
20s. I'm grateful, Lordship. I'm grateful. All the three matters will talk.
ওই যেরকম আছে সেরকমই দিয়ে দেবো।
Oh, yeah. I'm grateful.
Thank you.
No, no, only 9.
Mr. Honjo, Mr. Bhattacharya has not come to court today. Mr. Bhattacharya has not come to court today. Why is he not appearing? In the first matter also, he started with a duck. He has started with a duck. No. উনি আসুক, passport control
My lord, I have been requested by Mr. Devashish Ghosh, my landlord council, to pass over it, my lord, and if possible, my lord, kindly fix it at 2 p.m. because he is gone to his doctor, my lord, and he is coming from that, my lord.
passport করে রাখি। Next.
Chapter 13 is that cash seizure matter. My learned friend has shared with me the report. In the report, they have gone into the merits as to this is the allegation of ITC fraud and everything. And they are stating that cash means things. So therefore, they have seized. Lordship, I have provided your lordships my compilation that the courts have categorically held that there is no power because when goods specifically exclude money, therefore under the ambit of things, and unless it is why it is important for them to use it in the investigation, since 1.5 years they have not issued any show cause also, and they have kept this amount with them in their department. Lordship's judgment on this matter, when Lordships had categorically held that the use of this amount in investigation, if the department can bring on record that, in the report which has been shared by my learned friend yesterday, in this they have gone into the merits that it is a case of ITC fraud, and therefore it can be receipts of that fraud.
Can be not actually this is a receipt.
But Lordship, but I am not on the merits of the matter, Lordship. I have not challenged any search seizure operation. I am only that whether they can seize cash and keep with themselves and without any adjudication. Why this money? They are saying it is a proceeds of fake ITC that the SSC is into. But those are matters of adjudication, Lordships. Here I am my plea only before your Lords was that they don't have the power to seize cash, which is, Lordships, various high courts have now decided. Para 8 of their report. Second para 8. Last order. Compilation to the edge. Just have order. No. ওটা তো এই ওটা আছে হিমাংশু স্যার वाला केस না না हिमांशु सर वाला ऑर्डर है हाँ सॉफ्ट कॉपी नाइन वन फाइव फाइव मेरिट्स लिखा है ना पूरा রিপোর্টটা তো কালকে
We'll need to hear this thing.
Yes, fine.
We'll need to hear this.
And there is another judgment I just search out, though it is in the year of 2020. Madhya Pradesh High Court judgment has held that.
There was an admission which was later retracted.
Yes, my lord is referring Kanishka Matta. This is another judgment. My lord referring Kanishka Matta, Madhya Pradesh High Court judgment.
Maybe, I don't
Lordship,
remember.
I had in my compilation referred to Delhi, Kerala, which means
And
all
another
the
thing
views
is
have
that,
been
another
that.
thing is that, my
Show me
lord.
that judgment. Madhya
Yes,
Pradesh
yes,
High Court. देखिए.
Paragraph number 19. And on this issue, my lord, there are divergent views. Kerala, Delhi, Madhya Pradesh. Now that issue is pending now before the Supreme Court, and Supreme Court in its order is recorded. If your lordship kindly see, Gunjan Bindal. If your lordship kindly see. It is recorded in the order. In view of the submission that there is a conflict between the interpretation adopted by Delhi High Court, Madhya Pradesh High Court issue on the interpretation seeking condemnation suggestion.
There is no stay in any of the
I
orders.
am not saying that. Yes, then one order there is a stay, but I am not saying that. But your lordship have to consider on this perspective, because this is a fact. For bogus ITs, and that has been established. The husband of the petitioner, petitioner husband was arrested. Now this amount was seized from the Almira of that during the search. They failed to substantiate what is the source of that amount. So these have to gone into, my lord. This is not a simplicity that they are doing the business. This is absolutely a fraud. There is no transaction on the part of the transporter, and it appears that there is no such transaction, my lord.
1.5 years. Still no,
It is a
no
money trail. Well,
and
I
we are
have
enjoying the money.
I have 5 years to issue the shogun under section 74. Now my
So they will
investigation
keep the
is
money
going
for 5
on.
years, lordships.
Well, I have to, because if the investigation is going on, he cannot say, my lord, the mood and manner of the investigation. Petitioner cannot dictate, my
That
lord.
is why now the department's report is into the merits of the matter. Nowhere in the report.
Why?
Either my friend argues or I argue. Either he argues, let him complete, then I will. No problem. Please continue. No, you continue, sir.
You.
Lordship, what was held by a lordship by order dated 10th of December was the department has to see or has to ensure the relevance of this money in investigation. In the report which has been filed, lordship, may kindly take page 8 of the report.
Just a minute.
Lordship.
Just.
So photo ले लीजिए. This judgment was differentiated by Kerala High Court.
Which one?
This Madhya Pradesh High Court kindly takes my compilation first judgment. Shabu Gorge. It was differentiated. It was dealt by the Kerala High Court, and Kerala High Court was the SLP against Kerala High Court was dismissed. এখন তো একটাই আছে আগে ওর লাস্ট দিয়েছিল না আমার কাছে সাহেবকে দিয়েছে আপনাকে দিয়েছে আমার কাছে একটাই তো আছে আমি সফট কপি দিই হার্ড তো একই আছে স্যার আমি তারপরে দিই my lords is with that lords may kindly take para 3
नहीं तो
lordship third line above third line from below The judgment is there, MP High Court, what the court records. We must admit to being a bit puzzled by the stand taken by the said intelligence officer in the order dated this, and this is now produced before us by the learned government pleader, where while it may be a fact that section 67(2) authorizes the seizure of things including cash in appropriate cases, we do not see that the present case is called for a seizure of cash found in the premises of the appellant at the time of search. The power of any authority to seize anything while functioning under the provisions of a taxing statute must be guided and informed in the exercise of the object of the statute concerned. If an investigation aimed at detecting tax evasion under the Act, we fail to see how cash can be seized, especially when it is the admitted case that the cash did not form part of the stock of trade of the appellant business. It is evident that from the order of the intelligence officer, the cash that was seized on the premises was not stock in trade of the query business that was conducted by the appellant. The findings in the intelligence of it is suspicious that this much amount of money kept in the house of Mrs. This as idle and not deposited at bank, and further the amount received as gift on the day of marriage has not been recorded in his income tax return, and from this it is evident that the money is from illicit sources, reveal the extent to which authorities under the Act are misinformed of their powers and limits of their jurisdiction. Now here it's an admitted fact that the amount was found from my house.
No, but here
In my case,
it was the reasons for seizure were very scanty. They said it is suspicious,
Yes.
and the explanation that was offered was that it was received as gift. In your case, they have relied on your statements.
Lordship, no, Lordship. See, on the day of seizure, it was received, it was recovered from my house. Now in my house, there is nothing to show that it is a part of my business proceeds. There is no record. In fact, Lordship, I was therefore taking through their report. Kindly see, Lordship, page number 9 of their report, internal page 3, running page number 9.
Internal page 3, running page number 9.
Lordship, para number 8.
Yes.
They have quoted 67(2), Lordships. After the quote, from the provisions of section 67(2) mentioned supra, it is apparent that the things which are relevant to the proceedings are liable to seizure under proper authorization. The impugned seizure of cash was made on the strength of valid and legal search authorization in connection on the ongoing investigation. There is no mention as to the relevancy. What has fallen from your lords on the last occasion also, that how this seizure can be relevant to the proceedings. So, seeing to the second limb of 67(2), which my lords has decided in that judgment dated 10th of December in Puspa Furniture. Now,
Puspa Furniture, the facts were also the GST authorities themselves had approached the income tax authorities and said that it is. So that was the.
Lordship, in my case, they have took it to the department, kept it with them since 1.5 years, no adjudication, nothing.
So there in Puspa Furniture,
it was in the Almira.
GST authorities, although they said that there is suspicion, but their subsequent act of informing the income tax authorities.
Because Lordship, because they did not have the power to seize under GST, therefore they informed income tax.
No, if they thought that yes, this was a proceed of some clandestine deal, which they have benefited by way of defrauding or by way of evading tax, which was otherwise payable to the GST authorities, then they would not have informed the income tax department. They have informed the income tax department because they feel that it is not connected with GST, maybe with income tax. But that is
Lordship. Now in my case, Lordship,
that is what has happened in the
Lordship, in the present case, their report says it is things,
and this reasoning itself is more emboldened by the reasoning of the Kerala High Court, which you just now cited. They say that yes, if it is unaccounted, income tax authorities could have done.
Lordships.
So here, in your case, the case which we are now dealing with, in your case, they have come up with certain evidences which directly link it with the GST evasion.
Lordship, that is the thing, Lordship. They, in their report, they have just given that this firm is engaged into bogus ITC purchase and sales. So therefore, it is deemed. Now it is recovered from my house, not from my place of business. How can they link it? They have merely by writing that, okay, this would be a proceeds of that particular, cannot link it. And Lordship, 1.5 years, they say that I have 5 years time to do to issue a show cause. Till 1.5 years, they have not proceeded against me. They are keeping the
How
cash
do you
with me.
directly link it, Mr. Day? How do you link it? Merely because it is found. How do you say that it is only because of evasion of GST taxes?
The reason is there is no business at all. If there is no business at all, then they have, it is the responsibility or the obligation is upon them to explain how the cash is there. The burden of proof is solely fixed upon them. Now, Lordship kindly comes to para 13 at page 11 of my report.
Para 13.
Yes, at page 11, running page 11, the inner page is 5.
Para 13. Yes.
During search, a total sum of cash amounting to rupees 22,63,500 in form of different denomination was recovered from one of the almirah of the bedroom of Sri Shuman Bachwat. Sri Shuman Bachwat was the mastermind in the overall business activities of his 4 business firms, namely Messrs. SM Overseas, Messrs. Swastik Overseas, and Messrs. Mars Overseas. All his firms were found to be indulged in availment and passing off fake and bogus ITC as evident from their respective GST and 2A returns, where GST registration of numerous suppliers were found cancelled ab initio or retrospectively. Hence, during this search, Sri Shuman Bachawat and Srimati Purnima Bachawat, wife of Suman Bachawat, and other partner in the Messrs. SM Overseas, were interrogated about the cash amounting to rupees 22,62,500, and their statement was recorded. But they could not produce any satisfactory proof and could not justify the purpose for keeping the cash amounting to rupees 22,62,500 at residence. Since Sri Shuman Bachawat was engaged in issuance of the fake invoices, it was construed that the cash recovered was the proceeds in lieu of passing on fake ITC by issuing fake invoices.
Here also you have informed income tax authorities, no?
No. Because this is directly linked with the fake ITCs.
Lordship, now, Lordship, what they...
Accordingly, cash was seized video form number GST INS 02 under section 67(2) of the GST Act, CGST Act 2017. Therefore, all actions of the department are well within the proper jurisdiction and rightful in the eye of law. Therefore, we could have established, my lordship, a direct link. Now, lordship kindly comes to para 18 at page 12 further, 17 and 18. Sri Shuman Bachawat, para 17, has also deposed in his statement dated 10/10/24, which was taken in the judicial custody in presence of Controller, Presidency Correctional Home, Alipur 27, that he was offered some amount to make a company where he would be a proprietor. He deposed that he did not do business of his firms on his own. Now, Lordship kindly comes to para 18 further. The indulgence in cash transactions of the petitioner, along with his husband Sri Suman Bachawat, is also corroborated from the statement given by Sri Naveen Gupta, the proprietor of Messrs. Pragati Cargo Movers. From the records, it was found that Messrs. Pragati Cargo Movers was purportedly the main transporter as per the invoices of the firms of Sri Suman Bachawat. A summon was issued to Sri Naveen Gupta, proprietor of Messrs. Pragati Cargo Movers, on dated 25/7/2025 to appear on 1/8/2025. Sri Naveen Gupta appeared on 5/8/25 and his statement was recorded under section 70 of the CGST Act 2017. During his statement, he was asked multiple questions wherein he submitted his handwritten submission. Some of the relevant questions and their replies are as hereunder. It is observed from the records that you have provided transport services to Messrs. Global Exports. Please confirm the state and how did you conduct business with this? I have provided transport services to Messrs. Global Exports, but my role was only limited to issue consignment note. The copies of invoices were provided to me by Sri Rohit Shaw or Sri Sani Jaiswal. On the basis of those invoices, consignment notes were issued by me. Whether you provided vehicle for loading and unloading of goods or visited the site where goods were being loaded or unloaded. In case of Mrs. Global Exports and farms of Sri Suman Bachwat, I did not provide vehicles and issued only consignment notes. I also did not see any loading and unloading of goods. So actual transaction is being questioned here. Now, Lordship, kindly
But
come to
how are you
question.
linking it with that? Maybe it was smuggled. The money was smuggled.
Now,
money
they
was
say
stolen.
that they have carried on business, but the circumstantial evidence, their statement, the money being recovered from their premises, and there being no proper answer to validate such a recovery of huge
And
amount.
what will actually be done with this money? We come back to that. You cannot appropriate, or you can.
We
Because
can, my
it
lord,
is-
for the sake of, if you also kindly see section 67 once.
Because this question is there in yesterday.
In my other matter also.
Mr. Dhanuka is very keenly listening to this.
Mr. Dhanuka case is
yeah,
a very good
I
classical
can-
case, Lord. It will help all of us.
Mr. Dhanuka comes up with such case. Section 67.
Now, Lordship kindly sees subsection 2, the middle portion, where the proper officer not below the rank of joint commissioner, either pursuant to an inspection carried out under subsection 1 or otherwise, has reasons to believe that any goods liable to confiscation or any documents or books or things which in his opinion shall be useful for or relevant to any proceedings under this act. So therefore, my lord, investigation is going on. But so far the investigation has traveled. It seems, my lord, these are relevant and, my lord, useful for further course of investigation.
So why have we not? Why have the proceedings not culminated in issuance of a show cause?
Your lordship,
1 year
your
has
lordship,
gone.
your lordship, kindly appreciate, my lord. The culmination of the investigation takes some time, and it will certainly culminate by issuance of the show cause notice. It takes some time, and we have been given some.
1 year.
My lord, we have been provided by the statute the year 5 years term we have. So, my lord, so we cannot be blamed that we have traveled beyond the time period. Yes, no doubt 1 year has elapsed, and we are trying to, my lord, wrap it up and issue the show cause notice as soon as
When
possible.
we kept the next matter, the other matter? Yesterday's matter?
That is upon affidavit.
That is on
In
affidavit.
February, in the month of February.
Affidavit. Lordship, here October 24. In the report, it is only on assumption, presumption.
No, since Mr. Kanodia, the issue is of larger ramifications. It would have been a one-off case where they themselves have washed off their hands. It would have been easier for the court to
Lordship,
decide. So, at a stage where they put their foot down and contest, the court will have to come to a finding so that other matters of similar nature are guided.
Lordship.
Because Pushpa Furniture has not laid down any law.
Lordship.
Pushpa Furniture is in the peculiar facts of the case,
Lordship.
where they had themselves said, we have intimated to the income tax authorities will take action.
So in that
Therefore, we
case,
don't have.
Lordship allows me to file an exception because I received this yesterday night.
Rather than this, Mr. Dey,
My lord.
You file a composite affidavit.
Very good.
Because it should not take much time because your statements are already there in the report that you have filed, so that he may deal with it.
Yes.
You do it in 2 weeks.
Very well.
And he'll do it in 1 week.
Lordship, but since October 24, they are keeping. I am not getting any interest.
It will appear as motion as Mr. Dhanuka's case has been directed to appear.
Yes.
You don't prefer stay because it's all almost there, so that we come to a conclusion.
Yes,
And Pushpa furniture is not cited. Better decisions are cited
Yes.
because that's an interim order. So,
I'm grateful to your lordship.
yes,
I appear for petition.
who is appearing for the respondent?
Well,
Somebody
yesterday he
appeared. On the last occasion, someone was there.
Yesterday he appeared, well, and he submitted that one report was awaiting. So he was supposed to come with the report today.
You know him? Can you call him?
Today also, can I check?
I saw him just 10 minutes back.
Yes, Mr.
Yes,
Doctor.
Yes, I have it.
Well, this is a group 9 assigned matter. Well, what happened, well, I got an order for supply of medicines to the health department of Government of West Bengal. Well, I supplied the medicines. I raised the invoices, but my lord, I did not get the full value of my invoices, and there was a deduction of 10,50,000 and more. Look, I was given no show cause before that.
Against the deduction, you preferred an appeal.
I preferred an appeal.
Was not decided. You approached this court in writ petition.
Yes,
writ petition was decided, directing the appellate authority to decide. Appellate authority asked them to reassess. Now, reassessment has not been done as yet, and you have not got your due.
Exactly.
That is your case.
Exactly.
Yes, Mr. Das.
My case is below reassess has been done. Subsequently, they have received a payment also. And it sees the report.
Yes.
Yes. For the second page.
Can I have it?
Sure. আমার একটাই কপি আছে আমি আপনাকে দিচ্ছি in compliance second page third paragraph in compliance of the reasoned order 16 May 2024 the mission director health such and such with the order dated 3/5/2024 honorable high court the reassessment was done and found that there was 358 days delay to supply medicine because there was a delay issues. Therefore, the further amount of 1,30,582 was paid to the petitioner on the penalty charge remains 7,33,937, which has been deducted not due to petitioner since it is deducted as per terms and conditions of the tender notice. Now, the payment challan is annexed to the last page, page number 11. 1,30,582. 22nd July 2022.
So if something is disputed, writ court will not decide that.
No, my lord.
Whatever-
I tell you, lordship, my lord, what has happened, my lord.
No, not what has happened. If they have something, till such time it was there that it was, what is the reason for your deduction? Show me.
The reasons for deduction is below 22D, page number 41 of the writ petition.
No, in the report, where have you written?
In the report, I have written below, it's the first para of the first page. The supply schedule, maximum of 30 days without financial penalty. From the date of the order placed, another 10 days with financial penalty, which has been enumerated in clause number 22D, which is in page number 41 of the tender document.
You don't have any arbitration clause in the agreement?
Perhaps no, my lord.
No, my lord.
Who will decide the dispute? If there is a dispute,
But
So there is appellate court.
provision for appeal is
Appeal.
there, and we preferred appeal.
no, so against this order again, you can prefer appeal.
Yes, my lord.
No,
Why not?
why
I'll
not?
grant you. I cannot decide this because
No,
this
man,
is
I'm
something which
coming
is
to this,
factual.
man. The delay of they are saying the 358 something like that, man. Entirely incorrect, man. Well, basically there was no delay. Why I explain your lordship, my lord. My lord, kindly come to page, my lord, 48
of the writ petition.
of the writ petition, my lord.
Page 48.
Well, this is the order for supply. We received this order on 27 December 2022. Now, well, kindly come to page 49.
49.
Well, it is written that the entire supply of the tablet is to be completed to the district within 22nd January 2023. That means they have computed from 23rd December, since it was signed on 23rd December. So they computed 30 days from 23rd December. But I received this order on 27th itself, and there was already 4 days delay. Number one. Number two, my lord, kindly see, this order does not give the details of address of the stores where I had to send the medicines. So I immediately contacted the respondents for providing the detailed address, contact numbers, and GST number for sending the goods to the stores. But this was supplied to me only on 11th January 2023. That means, my lord, 15 days where already there was.
Very well. Where is the appellate authority's provision? You show me that.
23, clause number 23 of the tender, page number 42 of the tender.
42.
Yes, madam, clause 23.
And where is the appellate order which has been passed in terms of the High Court's direction?
My lord, at page 66, it starts from page 66, my lord. Page 67 onwards.
Mr. Dotto,
Yes, ma'am.
come to page 69. The appellate authority, paragraph A. The amount of dues in respect of invoices of the petitioner need to be reassessed along with receiving date in POD of the courier.
Yes.
So it has to be reassessed with
has to be
reference to the date on which he received,
Yes.
not the date on which you signed.
Not the, he has received on 27th December.
So 27 December to 30 days. From
30 days.
27 December will be when?
Yes, my lord. 27, kindly see para 8 of the writ petition.
Of the writ petition, yes.
Last line. Since the petitioner received the order on 27th December, the date of completion of supply within 30 days is to be counted, and it would be 26th January 2023.
Yes.
And they have completed the supplies in month of February. And that is
No,
the
my
date.
29 January, my lord. 29
Whatever.
January, we supplied
If it is
29 January.
January, there is a delay.
If the delay is strictly counted,
Well, I
was
will show that.
only 3 days delay was there. If this strictly counted.
Let me hear it. Yes, page.
Yes. Para 21
Of the writ petition.
of the writ petition.
Para 21. Para 14. I'm sorry, Mr. Para 14. Para 14. Yes. 1st February 2023 last date version.
That was in 2 places.
So 1st February means how many days delay? 27th, 26th, 27, 28, 29,
5
30,
days.
31, 5 days.
5 days delay.
And 6 days.
Yes.
So 6 days delay.
6 days.
So 6 days delay will come to how much?
That calculation
Then
was
1% of basic cost per day's delay up to 40th day. So 1% per days.
Yes.
So
So that is the as per writ petitioner's contention that I need to look.
No, my lord.
no,
Yes.
in your report,
Yes.
you
There's a
say that this,
358 days delay. Right.
so 6
This
days will,
calculation, Lordship.
yes. So 1% per day for 6 days, it will be 6%.
Yes.
And another point is, my lord,
6% is how much?
My lord, they had the right to accept related supply without
Very
penalty,
well.
without penalty, my lord. That is at page 42. That is a condition of the tender, my lord. Page 42, clause number 9, Roman 9. In fit cases.
Beyond 48.
Yes, my lord. In fit cases. So we explained the cause of delay before the appellate authority.
May I come back with the explanation of 358 days, my lord?
Yes, please come back. When?
Next,
Friday, next week.
next week, my lord.
Next week.
Next
Next week you will not have a Friday, then on 30th.
Wait.
30th.
No, my lord, can 21st? Next Wednesday?
Very well. If he is willing to give you, he'll give you, no direction. 15.
15, my lord, that.
Yes, Mr. Chakravarti.
Yesterday, my lord, heard that matter. And my lord, also, I'm carrying, my lord, our division bench judgment, my lord. May I submit that our
শেষের উপর
না তুমি ছিল ওটা
আরে অনেকগুলো তো থাকে মনে থাকে শেষের উপর
না 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 যে 10711 the that was in the context that if new point allegation come then 10711 but para 3 is the fact and 6 is the mallet content হ্যাঁ
And লিখে নিন। I'm disposing of. I'm sending it back to the appellate authority for reconsideration.
mallet
Mr. Bhattacharya has come.
Yes. This
তা
repetition
বলেছে অস্ট্রেলিয়াতে
assails and order dated
at page order mallet appellate order page 218
order dated December 19
and mallet
2024 passed by the appellate authority under section 107 of the WBGST Act stroke CGST Act WBGST Act 2017 stroke CGST Act 2017 whereby the petitioner's appeal against an order dated September 8 2023
yes page 56
has been disposed of upon modifying the adjudication order dated upon modifying the said adjudication order dated September 8, 2023. Full stop. Paragraph. The facts of the case in brief are that, comma, of the case in brief are that the petitioner was issued a notice to show cause under section 73.
Yes, my lord, 73.
73.
Page 47.
Of the said act of notice to show cause dated dated May 17, 2023. May 17, 2023. Under section 73 of the said act of 2017, whereby the petitioner was called upon to explain certain discrepancies in the petitioner's returns, i.e. GSTR1, GSTR2A, GSTR9 and GSTR9C for the period July 2017 to March 2018. 2017 to March 2018. Mr. Rai, please correct me if I am wrong.
Yes, madam. 17.8.
Paragraph. The petitioner, you replied to that?
No, madam. There all the uploaded in the additional portal,
The
all this ex parte adjudication.
The petitioner could not reply to the said notice to show cause in as much as the petitioner could not reply to the said notice to show cause in as much as the petitioner did not have knowledge of the show cause notice, since the same had been uploaded on the GSTE portal under the additional notices and orders tab. Full stop. Paragraph. Since the notice to show cause went unreplied, the adjudicating authority passed the adjudication order on September 8, 2023. full stop, comma, thereby raising a demand against the petitioner, full stop, paragraph. The petitioner carried the adjudication order in appeal before the appellate authority, full stop. The appellate authority agreed with the submissions of the petitioner and where is the adjudication order?
My lord, adjudication order at operative part, my lord, page 60. 60, 61, my lord. This order also, my lord, 75(6) violation, my lord. Details order, details fact not set out, my lord.
So here the show cause notice, whatever was demanded, that was confirmed in the adjudication order.
No, in the appeal order, my lord.
No, I'm talking about the
Yes, yes,
adjudication order. Please answer the query of the court. Show cause was confirmed in the adjudication order. That was not modified.
Not.
Please answer whatever I'm asking.
Yes.
Don't go beyond that.
Sorry.
That creates confusion. Carried the adjudication order in appeal before the appellate authority, full stop. The appellate authority, upon considering the petitioner's appeal, agreed with the petitioners on how many allegations were there in the show cause notice?
Total, my lord, 3 allegations there.
What were those?
One at, my lord.
Show me.
Yes. Page, my lord, 38, starting page, my lord. Annexure of intimation, my lord.
Page 38.
Page 38, point number 1, taxability on outward supply. Lordship got, my lord, 38.
Just a minute. এই যেখানে ইয়ে লিখেছেন show cause notice এর একদম উপরে যখন লিখেছেন notice to show cause বলে শুদ্ধ করে এক জায়গায় লিখেছেন facts of the case briefly যেখানে আছে লিখেছেন তো ওই জায়গাটা একটু অ্যাড করবেন. Where is the show cause notice? Show me from the show cause notice.
Show cause notice, my lord.
Page 44.
40, starting page 47.
44.
44. My lord, this is, my lord, part of the intimation, my lord.
Very well. Page 47.
Starting page, my lord, and operative part, my lord, at page 52, my lord. These allegations also details here not given, only given in the annexure of the intimation, my lord. This is only the figures, my lord.
So intimation is the is what contains the details.
Yes, my lord. This contains the details, and also show cause notice is also non-speaking.
The show cause notice is non-speaking. However, the intimations which preceded the intimation notices which preceded the show cause indicate that the petitioner was sought to be foisted with tax liability, foisted, F-O-I-S-T-E-D, foisted with tax liability on 3 counts. A, tax not paid on outward supply. B, tax not paid on inward supply within bracket RCM.
Yes.
C, ITC found reversible. Availed ITC found reversible. Availed ITC found reversible. ঠিক আছে?
Yes.
এবার শেষে যেখানে এসছে সেখানে এটা ওখানে অ্যাড করি. এবার কি লিখেছিল শেষে? অ্যাপেলেট কোর্ট না অ্যাপেলেট অথরিটি. upon considering the petitioner's appeal, petitioner's contention in the appeal, petitioner's contention in the appeal, agreed with the petitioner on 2 counts. I.e., no, the petitioner agreed, you admitted.
I admitted allegation A and B, and C, my lord, converted into 0, nil.
Agreed, agreed with the petitioner on the point of reversibility of ITC and nullified the demand on that count. Full stop. Insofar as the first 2 grounds of imposition of tax contained in the notice to show cause are concerned, the petitioner admitted the same before the appellate authority.
Yes, ma'am.
Full stop. However, the appellate authority went a step ahead, the appellate authority went a step ahead and imposed further tax on the petitioner on the ground that the petitioner had claimed excess zero rated supply to the tune of rupees 27,16,811, which required to be added to the turnover of taxable supply and was required to be taxed in the 18% category. Full stop. To be precise, the appellate authority held as follows. The appellate authority held as follows. Page 222. যেটা আমি লাল দিয়ে করেছি এটা ঠিক আছে the petitioner is aggrieved. The petitioner is aggrieved by the aforesaid observation of the appellate authority. Full stop. Hence the writ petition. Paragraph. Mr. Rai, it's clear?
Yes, madam.
Mr. Rai, learned advocate appearing for the petitioner, submits that the ground on which the petitioner's turnover of taxable supply has been increased, was never put to the petitioner, and as such the petitioner had no opportunity to rebut the same. It is submitted that in any case, the observation of the appellate authority is factually incorrect, inasmuch as the appellate authority has taken the value of the petitioner's zero rated supply to be rupees 2,22,74,656 as claimed in GSTR 1/3B/9, while the actual value of zero rated supply was rupees 1,95,57,845. It is submitted by Mr. Rai that the petitioner had earlier committed a mistake by incorporating the figure 2,22,74,756 in which return
My lord,
Nine,
no, 9 rectified, but committed mistake in 3B.
In 3B, in form 3B, which was later rectified
Yes,
by the petitioner
annual
by
return.
filing form GSTR 9.
9C.
For filing return in form GSTR 9 and
Uh,
GSTR 9C.
9C.
Capital C. Full stop. Paragraph. Mr. Rai, learned advocate appearing for the petitioner, invites the attention of this court to the provisions of section 107 within bracket 11 of the Fed Act of 2017 and submits that the appellate authority was obliged to give the petitioner an opportunity of rebutting the appellate authority's contention if the appellate authority was contemplating increment of imposition of tax on the petitioner. Imposition of tax on the petitioner. Full stop. Paragraph. In support of his submission, Mr. Kanodia, Mr. Rai has relied on a judgment passed by the Honorable Division Bench of this court in the case of full stop. Paragraph. Mr. Chakraborty, learned advocate appearing for the respondent SGST authorities, submits that the order impugned has been passed by the appellate authority upon due application of mine. Full stop. He seeks to support the order on the basis of the material already on record. Full stop. Paragraph. Heard learned advocates appearing for the respective parties and considered the material on record. Full stop. Paragraph. It is clear from the adjudication order as well as the intimation notices which form the basis of the show cause notice that the petitioner had been questioned on three counts, i.e. Full stop. The issue as to whether the petitioner's turnover of taxable supply would get increased or not was not before the adjudicating authority. Full stop. Furthermore, it also appears that the appellate authority has not applied its mind by taking a figure mentioned in form GSTR 3 without considering the rectification thereof in form GSTR 9 and 9C. GSTR 9 and 9C as claimed by the petitioner. Full stop. In such view of the matter, the appellate authority must reconsider the aspect upon giving the petitioner an opportunity of affording the petitioner an opportunity of being heard. Full stop. Paragraph. for only on the aforesaid ground, comma, the order passed by the appellate authority to the extent it imposes liability on the petitioner on the ground of tax short paid on outward supply is set aside, full stop. The matter is remanded to the file of the appellate authority only for consideration of the said aspect, nothing else, because other you have admitted.
Yes, yes. Admitted and also modified. Another
In
question.
as much as the other grounds could admitted by the petitioner.
And one ground, my lord, modified.
3 grounds were there.
Yes, yes. One ground modified to nil, 2 ground I admitted.
Full stop. Paragraph. The tax rate WPA 6227 of 2025 stands disposed of with the above occupation.
My lord, one liberty may be given because my lord, this allegation raises without show cause.
They will give you opportunity of hearing.
Maybe, my lord, subject to correction, one liberty to file additional reply, my lord, because the fact is so critical.
The petitioner shall also have liberty to file an additional reply. Also have liberty to file an additional reply dealing with the appellate authority's contention as regards increase in turnover of taxable supply.
And my lord, subject to correction, the rectification on in appeal is required to be also set aside. Page 230, madam. 230, the second line, madam, and 231, madam. I have applied for rectification. That also rejected by one line order. No order passed. Page 230, second line.
Fact ekdom fact যেখানে লিখেছেন না, hence the repetition তার আগে একবার the petitioner thereafter filed an application for rectification before the appellate authority
on
seeking rectification of the appellate order.
Yes.
On
30 December 2024.
December 30, 2024. The said rectification order, said rectification application was also dismissed.
Rejected
by an order dated.
No order passed, but mentioned on the portal only 21st January 2025.
Also stood rejected, but the petitioner has not yet been communicated with the reasons for such rejection.
Yes, madam.
But the petitioner has not yet been communicated with the reasons for such rejection. Full stop. Hence this writ petition বলে আছে, এবার নিচে লিখেছে একদম শেষ. Since the appellate order has been interfered with to the extent the appellate order has increased the taxable supply, turnover of taxable supply of the petitioner and taxed the petitioner on that, comma, the petitioner's rectification application that becomes meaningless.
Yes, my lord. Appeal about
no,
the petitioner, the rejection of the petitioner's application for rectification. The rejection of the petitioner's application for rectification would also stand set aside. Full stop. The application for rectification of the appellate order will be considered by the appellate authority along with the petitioner's reply to the contention of the appellate authority in terms of this. And both you will consider.
Yes. My duty, my lord, to mention. And
you will consider both.
Yes.
My learned friend has not
I'll come back in 5 minutes. Yes. Mr. Bhattacharya, don't run away. I'll come back.
এটা কভারটা না
ওই ইয়ে মেথড ছিল না বের হয়ে তেরো তেরোতে Yes, Mr. Bhattacharya.
My lord, lastly, your lordship, my lord, in respect of the, my lord, the circular dated 29 September 2016, my lord, there is some discrepancies. I think there is misunderstanding between, my lord, me also, my lord, because, but I am now clear. If your lordship takes up that circular, my lord.
Direct for the rest.
Second page, kindly come, my lord. Kindly, my lord,
Second page.
serial number 2, my lord, kindly see, my lord.
Yes.
Adjudication of confiscation and penalty of central excise officer is provided in section 33 of the 1944. Central excise officer have the power under section 11 capital A to adjudicate so-called notices demanding duty short paid or not paid and erroneously refunded. Similar power exists in service tax under section 73 and section 83 capital A of the Finance Act 1994. It is hereby directed that henceforth power of adjudication both in central excise and service tax shall be exercised based on the monetary limit of the duty tax credit involved in a case as under. Then, my lord, serial number 1. Superintendent not exceeding rupees 10 lakhs. If I pause here, my lord, therefore, the duty, well, that was in respect of the duty which has been short paid or not paid. That issue can be adjudicated by the superintendent up to 10 lakhs, my lord. Now, my lord, I am coming to I, my lord, kindly see. Cases involving taxability, classification, valuation, and extended period of limitation. This inquiry, if had been required to be made, my lord, then superintendent has got no power.
Right.
Otherwise, superintendent has the power up to 10 lakhs, my lord. He can adjudicate
up to 10 lakhs only for the purpose of
duty
short
which
paid.
has been short paid, not paid.
Yes.
Therefore, the
duty short paid, not paid.
Not paid. Therefore, only when it will be, my lord, taxability, classification, or extended period when it question will be arise, my lord, investigation is required, inquiry is required, my lord. In then only superintendent has got no power. Then deputy commissioner.
In this case, what is the case?
There is short paid, not paid, my lord. If your lordship can takes up the show cause notice, my lord, I will come. No, that is the case. I am not saying anything.
Yes.
My lord, kindly sees, my lord. Show cause notice, page 26. I have not determined the correct taxable amounts in ST3 returns as required under section 66B and 67 and 68 of the said Act, resulting short payment of service tax.
And Mr. Khan submitted that it falls within extended period of limitation.
My lord, extended period, I am saying, my lord, self-assessment is a very onerous duty for the assessee. He will have to file the return in true sense of the act itself. Once he didn't, my lord, then it's a clear case of suppression. Then extended
No,
period.
but if it falls under extended period, if it is, then it involves extended period.
No.
If it involves extended period,
then
again it goes out.
superintendent has got no jurisdiction.
Yes.
That I agree with you, lordship. My lord.
So then in that case it goes out. Here
But
it is.
yes.
It is a case of extended period only.
Yes, but not only I am saying, my lord, here, my lord. Two things are there. One is, my lord, the superintendent power only short paid in case of
If
short paid has the
extended period is not involved.
involved, then only yes.
Not
Yes.
only-
Now
not
your
involved.
lordship pass the order.
Now, if extended, Mr. Khan, please show me how extended period is involved. Kindly come to page 29, my lord. Yes, 29. Here, 0.5. Yes, Mr.
Yes.
Bhattacharya.
My lord.
Page 29,
My lord.
5.1.
Yes. It appears, my lord, leaving 3/4 lines, my lord. It appears that in the instant case, the said assessee have intentionally made willful misstatement in the ST3 returns by
Very well.
suppressing.
So in that case, instead of superintendent, somebody else should have done
Yes,
this.
correct. That is there. That is there. Only I am trying to clarify the
No,
notification.
that I understand.
My lord.
So superintendent will, yeah, in
Has
any
no
case,
jurisdiction, my lord.
again lose power.
Yes. But my lord, this issue with regard to respondent submitting, my lord, even the adjudicating authority, my lord, they didn't raise intrusions there, my lord. Well, they have not raised any whisper regarding this.
Jurisdictional issue of
Well,
jurisdiction.
once, my lord, subject to your lord's consent, once I have considered to the jurisdiction, my lord, it applies in arbitration cases I have seen in various matters, my lord. Once you have considered to the jurisdiction, my lord, you don't have any right to raise this question of jurisdiction of the arbitrator.
If the question is of dual nature, if there is inherent lack of jurisdiction, then in that case, even if you have participated, the order will be a nullity. If the jurisdiction is, for example, if it is not inherent, it is some sort of territorial jurisdiction. The authority otherwise has jurisdiction over the subject matter. Then in that case, it can do. Here, he does not have jurisdiction over the subject matter.
My lord, one arbitration, but I am telling you, lords, my lord, not in this tax matter, but in constitutional bench, my lord, held that once you have considered the jurisdiction, you can raise the question of jurisdiction of the arbitrator. You have participated in the arbitration. It is also
subject
similar.
matter jurisdiction. There are several judgments that if it is the jurisdiction,
My lord, he has participated. He didn't raise the whisper.
Participation will not confer jurisdiction if the authority does not have jurisdiction. That is why the question is whether the jurisdiction, lack of jurisdiction is inherent or not. If it is inherent, then it cannot be waived.
But
If it is not inherent, for example, if it is territorial, say in civil court parlance, territorial jurisdiction, this court did not have, this court has.
There
Then
is
in
no
that
question of
case,
inherent lack of jurisdiction.
No, there is no inherent lack of jurisdiction. In such cases, if the parties have parties, that is why it is said that at the first instance you have to raise the ground.
Yes.
If you don't raise it,
Yes.
the court has gone.
Yes.
To a certain extent, it will have power.
Correct.
Rather pecuniary.
Pecuniary also, my lord, in
Same
two
thing.
cases, my lord, court held that no, once you have not didn't raise any whisper, even well, suppose wrongly leave has
If
been
it is
granted to
inherent lack
initiation.
of jurisdiction. For example, if before the DRT you have filed a divorce suit, both the parties have gone. DRT has granted decree of divorce.
My lord.
Can the party say that no, the DRT had jurisdiction?
Correct.
You cannot say that.
It's binding upon.
It's inherent lack of jurisdiction.
But at the threshold, he ought to have raised this point, but he didn't do
He
it.
should have raised.
Now, my lord, after passing the order, not only twice, one it has been passed, it is remanded back. Then again, adjudication was made. He didn't raise any whisper, neither two adjudicating
Mr.
authorities.
Khan, you have that judgment of subject matter jurisdiction. That subject matter jurisdiction is important.
Malay, here also monetary.
In
Kindly,
case of subject matter
my lord, here,
jurisdiction, participation will not confer jurisdiction if the authority does not.
my lord, here also, my lord, response submitted, my lord, the question of extended period is only involved, nothing more, my lord. This is the only issue here. Otherwise, superintendent has the jurisdiction because it is short paid. It is short paid. He has within the domain, my lord. He can issue the so-called notice. He can adjudicate also, my lord.
Just limiting speech to one, but actually there are three jurisdictional challenges. One challenge is also on the ground that they lack territorial jurisdiction. Because I have been, this order has been passed by somebody posted in Malabata division, while within their knowledge, I am within the jurisdiction of Vidhannagar jurisdiction. That is first point. Like this is also equally fatal. And then there is, since they are invoking extended period of limitation, they must provide the basic jurisdictional points that there is a collusion, there is a suppression, there is something. Now, no such allegation except false narration has been copied. And Supreme Court has said that these allegations should be made specifically in such manner that the party gets an opportunity to rebut those. So these three fatal.
Shokos was very clear, my lord. Shokos was very clear.
Just saying that you have.
He could have raised this point that you don't have any jurisdiction because you have the question of extended period is involved, and also my office is located at initially it was within the domain of my lord Bora Bazar. Subsequently, he transferred his office to the Salt Lake that only. That territorial question, my lord.
With knowledge.
But industrial monetary limit, centralist officer has that domain to issue the so-called notice.
If you see section 21 of the CPC,
My lord.
for pecuniary and territorial, you have to take the objection at the threshold.
Yes.
So far as other inherent jurisdiction is concerned, you can take it at any point of time. At the threshold, if you don't take, under CPC also, no objection as to the place of suing, no objection as to the competence with reference to pecuniary.
My lord.
These two objections are fatal if you don't take at the
At the initial
threshold.
stage, therefore you are not entitled.
Then in the appellate court, it will not be entertained.
Correct.
So far as inherent lack is concerned, this is kind of an inherent lack.
Well, whether I put this question to myself, whether the question of extended period can be an inherent lack of jurisdiction. Well, had it been a case, my lord,
Why not?
because monetary limit was within his domain, my lord. To 10 lakhs up to 10 lakhs.
Monetary limit can be waived. Monetary limit is something which can, because it is pecuniary. Rather, that would not have been subject matter. Subject matter is whether he can decide
The question
cases
of extended
beyond a particular period. That becomes vital. That can be sort of subject matter. Yes, Mr. Khan, let me see what judgment you have. So there are several judgments on subject matter jurisdiction. I had occasion to argue.
also,
this.
Himalaya, the notification itself is binding also. The notification itself is.
Upon territorial jurisdiction, it says that once the act or rule.
And what about the territorial jurisdiction? Territorial jurisdiction.
But
we
it
had-
was originally under Bora jurisdiction, my lord. Subsequently, he transferred it from the, and he received the all notices there, my lord. He did not, it is not a fact that he did not know anything. Rather, he knows everything, but did not raise any whisper anywhere. Then why you are sending the so-called notice to me at Salt Lake? Why you have participated? Why he has participated twice? First adjudication, remanded back. Second adjudication, didn't raise any whisper.
Very well, then I will have to supply my subject matter jurisdiction judgments because both parties don't have.
That will be then cited subsequently.
I will.
But I know, my lord, 2005 Supreme Court cases, 2005 Supreme Court pays probably 3. But there Supreme Court says yes, if it is a inherent lack of jurisdiction, even SLP stage, it can be raised. Now my
First judgment is Kiran Singh, Chaman Paswan.
Yes.
1954. That is the parent judgment, which says that any judgment or even decree passed without jurisdiction, or there is inherent lack of jurisdiction, can be challenged at any stage, even in collateral proceedings.
Yes, yes.
Even in collateral proceedings. Kiran Singh versus Chaman Paswan.
Only, if your lordship will supplement anything regarding extended period, whether it's within the meaning of inherent lack of jurisdiction. In a question where extended period is involved, whether it is within the question of inherent lack of jurisdiction. A person having pecuniary jurisdiction, he can adjudicate everything, only period of extended period, whether it can be said that it's an inherent lack of jurisdiction. That issue will.
Very well, I will decide that.
My lord, my lord.
learned friend is not making submission on other points, substantial challenges.
If on jurisdiction it
Only
goes, I will not deal with
Everything
that.
else, like supposing, assuming that he succeeds on whatever he's reading now, then I will have to go back to that territorial jurisdiction. Even if that
Yes, Mr. Bhattacharya, on territorial jurisdiction, what is your submission?
my submission, my lord, territorial cannot be, my lord, held as an inherent lack of jurisdiction. My lord, he participated, once he has participated, my lord, he stopped the ML. He cannot raise any question.
So, the answer to that is the Supreme Court judgment which I cited.
which I just cited, my lord.
Give me a copy, I will answer, my lord, then.
Please give him the
The
citation.
latest constitutional bench judgment of the, my lord, Honorable Supreme Court in a case of arbitration, my lord, there it has been held. Well, Vidya Durulia, there it has been held once you have considered jurisdiction.
But that is not in income tax parlance. That is in civil parlance.
Civil parlance, yes.
There is a difference.
Very well, my lord, I will find it out, my lord.
Very well, I will also consider.
Well,
দিদি এটা দিয়ে দেবেন বাড়িতে।
And the third issue, substantial issue, is whether where this allegation 600 pages go without making a specific allegation on that point.
That, Mr. Khan, is a mixed question of law and facts.
There's
no nothing, no allegation.
no, you prefer appeal, get it resolved there. Why did court will
Mixed
decide?
question of law and facts. In case these 2 points go, then in that case you can always challenge that in appeal.
It is palpably evident that there is no such allegation. Palpably evident from the.
No, even that these are factual things, my lord. He could prefer the appeal.
No, if the show cause notice itself does not show that there is allegation of suppression. then
No,
in
so
that
called
case-
itself, my lord, your lordship has
that
seen.
Allegation has to be specific in a manner that I can answer to it. Just saying there is suppression with suppression, so I.
ST3 return itself is a complete.
Supreme Court is clear on that. That
You have the judgment.
I have, but I think I was carrying on one copy I can show, then I will bring the.
Please bring that and please give him the citation also so that he can also come ready, because in piecemeal will not go like that.
The more citation will read my understanding.
No, no. What about this Supreme Court judgment?
More.
Where is the citation? Today you are giving.
And this is judgment, marked by me, I haven't copied it, I will bring it. Just the head notes and the last 2 pages, they will indicate what Supreme Court decides about this thing. The head note is indicating what the nature of universe, and the paragraph 55 will indicate.
brief to the file. পাঠিয়ে দেবো স্টাডি আমার একটা কপি দিন আমার একটা কপি হবে এটা আমাদের পাস করতে বলুন দিয়ে দেবে কপি লাগছে
Well, 69 for the respondent. The DGJ.
May it please your lordships. May it please your lordships.
Yes.
In the previous matter, lordship, the citation is 1954 1 SCC 710. My lords, your lordships were just now referring to Kiran Singh. I'm just providing the citation, my lords. 1954 1 SCC 710, my lords.
Yes, that is gone. It is done.
Lordships. My apology, miss. My apology.
Yes, what is the matter?
My lords, this petition challenges the order passed by the authority, my lords. My lords, the essentially jurisdictional 2 grounds are being raised, my lords. One is based on, my lords, whether they could issue a consolidated notice and a consolidated adjudication order That issue is being addressed by your lordships in one petition, my lords, before this court. My lords, the compilation my learned friend has handed over, my lords, to your lordships.
Yes.
My lords, item number 1, serial number 1 in the compilation is the order passed by your lordships, my lords, in an identical petition that your lordships are at this issue is being addressed before this honorable court, my lords.
Yes.
Lordship, this issue, my lords, whether they could have issued a consolidated notice and a consolidated adjudication order, my lords, the issue has been decided now, saying that this cannot be done by the Honorable Bombay High Court Division Bench of the Bombay High Court, the Kerala High Court, the Andhra Pradesh High Court, the Karnataka High Court, the Madras High Court, my lords. Recent judgment of the Karnataka High Court, my lords, considering all these decisions, is also placed on your lordship's file, my lords.
Right. That is
May-
the only issue.
May I just point out, my lords? That is one of the issues, my lords. That's one of the issues. The other issue is, my lords, whether under section 6(2)(b), your lordships are aware now the Supreme Court in armor security has decided that a dual adjudication for the same cannot be done. And if your lordship sees the order, my lords, I specifically raise this contention. There is no finding by the adjudicating authority on these points, my lords.
Where is the order?
If your lordships have page, lordship may kindly have this contention, my lords. The order, my lords, starts at running page, annexure T1, page 111,
111. Yes.
111, my lords. And there, my lords, lordship may kindly have para page 151, my lords, page running page 151. It's a part of my submission recorded in the impugn order itself, my lords.
Page 151.
Page 151.
Yes.
It records my submission, my lords. Lordships have capital D, my lords.
Yes.
Proceedings initiated by DGGI for the same issue for which anti-evasion unit has already initiated inquiry and various submissions made causing unnecessary harassment and duplicate efforts for MIPL. Your lordships have that, my lords?
Yes.
Lordships. We would like to bring to your kind attention the fact that we have received summons from the Superintendent of CSG Anti-Evasion, Kolkata South Commissionerate. These summons were issued under CBIC DIN dated 24 and subsequently 29/4/24. In response to the said summons, we diligently provided both hard and soft copies of the required documents dating back to the inception of GST for the period from 2017 till 31st of March 2024. Copy of our submissions in our letter dated 29/4/24 and 7/6/24 are attached. Furthermore, we comprehensively responded to all the queries raised by anti-evasion team on 5/6/24 and give our written statement also concerned before authority. At present, we are
Mr.
fully.
Rachandani,
My apology.
in the proceedings which have been initiated by the state authorities,
Lordships.
whether any show cause notice has been issued?
My lords, they have closed the proceedings. That's
Closed
my
the
submission, my
proceedings
lords.
prior to the initiation of this.
Lordship, my lords, during the course of initiation of this, my lords.
So when was the show cause notice issued by the state authorities?
My lords, this show cause has been issued by the DGJ authorities, my lords. My lords, the
Show cause
state
which is
authority.
impugned in the present writ petition has been issued by the DGGI.
DGJ authorities, lordships.
Very well. Prior to that, the show cause notice on the basis of which you say that parallel proceedings are being continued.
Lordships.
When was the other show cause notice issued?
No, my lords, the state had issued summons. They had started inquiry. They had issued notice. We have replied. And then they have closed the proceedings. They have not taken any further action. Our contention was this, that they have initiated proceedings, closed the proceedings. On the same
No, but
basis,
in
you cannot.
armor securities, Mr. Rachandani, the ratio was that proceedings will be said to have been initiated upon issuance of a notice to show cause. Issuance of summons will not give rise to proceedings.
Lordships, my lords, I'll show certain paragraphs from our lords for my lords' kind consideration. That specifically this very point for the entire period, for the same period, the state was investigating.
May have been, but till such time that the proceedings are actually started, if it is
Lordships.
only at the stage of summons and not proceeding further, then that does not mean that proceedings have been initiated.
No, my lords, they
Proceedings
have
will
closed.
get.
Your lordship said right, my lords. My apology. Your lordship, they have closed the proceedings. My submission is that only. That's why the state and center both are respondents. They can make a statement whether the state concluded the proceedings or not. If the state has concluded the proceedings, my lords, armor
No,
directly applies.
it won't mean it in the technical sense. You may call it closure, but I won't say closure because closure of proceeding will come to the closure of proceeding can only be said to have been done if proceeding has been initiated at the first instance.
Lordship,
If it is only at the stage of investigation and after investigation is not carried forward so that show cause is issued, that will not amount to closure of proceedings. They have not
Lordship.
proceeded with the investigation any further is what can be made out.
Lordship,
But that will not preclude the other authority from investigating further and issuing a show cause.
Lordship, in RP BuildCon, your lordships have taken a view that the authority which starts first will complete and initiate the conclusion of the proceedings, my
No,
lords.
but
That's my submission.
that has now been overridden by the Supreme Court in the sense that Honorable Supreme Court in Armor Securities have said that the authorities will act in tandem with each other. They will decide amongst themselves as to who is the authority who is going to conclude the proceedings. If
Lordships.
if they do not come to a decision, it is only in such cases that the authority who first started will conclude first.
Will conclude that,
was the
lordships.
ratio.
Lordship. Then I'll, my lords, then I'll
Not that
just.
in all the cases the first authority will conclude first. And the first authority has not initiated the proceeding. Where is the question of conclusion? Initiation will begin with issuance of show cause. Before that, it is only preparation for initiation. That is what the meaning of Armor Securities is.
Lordships. Manoj, then Manoj, may I just find out, Manoj, what happened to the state investigation? I'll take instructions from the client what happened ultimately to the state investigation.
Please
And then
take
I'll place it for your lordship's kind consideration tomorrow, my lords.
Very well. Tomorrow it will not be taken up because tomorrow you have a different set of matters. It won't be taken up tomorrow.
My lords, I'll appear physically before your lordships, my lord. I'll assist your lordships physically.
That's right, but tomorrow I don't take up these matters. These matters will come up in the next week now because tomorrow will be the day for unauthorized occupants matters.
Oh, lordships, my apology, my lord.
Very well.
Then Monday, my lords, Monday, lord, subject to your lordships convenience.
I'll fix a date. I'll fix a date. Heard Mr. Raichandani, learned advocate, appearing for the petitioner, and Mr. Bhattacharya, learned advocate, appearing for the CGST authorities. Full stop. Mr. Raichandani seeks some time to take further instructions in the matter. Full stop. Accordingly, list this matter once again on January 27th, 2026. 27th will be 28th. January 28th.
Lordship, can it be next week, my lords? My apology, my lords. 28th, I might have to be in the apex court, my lords. 21 or 22 subject to your lordship's convenience, my lords.
22 will again be Thursdays.
my
I will not
apology.
be taking up these
My
matters.
apology, my lords. My apology. Then, my lords, 20, my lords.
2021, I already have fixed and continuing matters. I don't know whether I'll be able to take up or not.
My sincere apology. Lordship, then can it be 4th, my lords? 4th of February?
February 4.
4th
February
of February.
4, 2026.
Lordship, please agree. Grateful. My apology, my lords, for the date, my lords.
I've written that. I've written it by your name. Mr. Rachandani, please make over a copy of the compilation to your learned friend also.
I hand it over, Manoj. I'll ask my colleague to hand it over just now, Manoj, a photocopy of that.
No.
Subsequently, also there are developments, Manoj, which I'll place before your lordships, Manoj, on the first point of consolidated notice, Manoj. Manoj, the Honorable Allahabad High Court has...
Because Mr. Rachandani, at the threshold, there are conflicting views on the issuance of consolidated notices also. There is a Delhi
that's
view
what
which has...
I want to point out, your lordship, my lords, after the Delhi High Court judgment, a writ petition was filed under Article 32 before the Supreme Court by a Delhi-based assessee saying that the Delhi High Court has already taken a view. That Supreme Court gave liberty to that assessee to approach the Delhi High Court again and cite judgments of the Karnataka and Madras High Court judgments. And after that, my lords, the Delhi High Court has issued notice in that matter and considering that matter again, my lords. I want to place it before your lordships.
Very well,
And
please do so.
and secondly, my lords, the division bench of the Allahabad High Court has heard these matters and closed for orders, as well as the Honorable Punjab and Haryana High Court. My lords, I'll place it before your lordships, my lords.
Very well.
Lordships, because this issue, my lords, your lordships have to address the have to decide
Yes,
this
yes,
issue.
I will
Therefore, I'll
have
address
to.
it before your lordships, my lords. Certainly, my lords, certainly.
Very
And certainly, my lords, these are all persuasive value. Your lordships will have to decide it, my lords. Certainly. I'm obliged, my lords. I'm obliged.
Thank
I'm
you.
obliged,
Thank
my lords. Grateful, grateful.
You're appearing, Mr. Banerjee. Yes, Mr. Banerjee. After Mohit Minerals and this Honorable Court's division bench judgment, what remains here? It's there in the order. What more will you say? It's there in the order itself. The amendment of notification will not override the Supreme Court judgment, because a judgment, as we all know, will always be having retrospective effect unless it is said to be prospective. That is the difference between statute and judgment. Statute will always be prospective unless it is stated to be retrospective. A judgment will always be retrospective unless it is stated to be prospective. Because judgment is not legislation. It only declares the law as it is. So it will take effect from the date of the law. That is what the law is. Supreme Court says, no, law is not this, law is this. So whatever the law is, the law will be from the date on which it was enacted. It's as simple as that. But be present, because see, last time also you took time thereafter. But thereafter you didn't appear. Nobody appeared. And on one occasion I passed over without passing any order. That is why there is no record. Otherwise, there are 2 occasions when there have been defaults. You are raising demands also. Please be on Monday, because I would not like unnecessarily to adjourn it. Please be here on 19th. I'm making it on 19th. I'm recording that. Mr. Banerjee, learned advocate appearing for the respondents, seeks some more time to take appropriate instructions, full stop. Since the matter has been pending since long, it is expected that Mr. Banerjee would be ready with appropriate instructions by the returnable date, full stop. As requested, list this matter once again on January 19, 2026, full stop. Next. What is this?
Well, I don't know my EP. The issue is that I'm against an order passed by the state tax authority, well, I'm under the administrative authority of central jurisdiction. If I want to go to the show cause notice, which is on page 48, my lord.
Yes.
Yes, my lord, the brief taxabilities that are given in the there's a reconciliation difference being brought out between 3B, 1 and my books of accounts. And 3B is a return filed by me. It is for my taxes due and my ITC and claim. East year 1 is a statement of outward taxes, supplying, reporting all my output. Books of accounts are the books which I have already furnished along with GST and 9C. So all these three data are taken from my data, my lord. So therefore, my first argument is that it is not a part of an enforcement activity. And therefore, there is no jurisdiction lying with the state tax authorities for this.
I couldn't get you. It has been taken from your data, therefore it is not part of enforcement agency means?
Well, a part of scrutiny of assessment, scrutiny of return, which is given in section 61. So this is purely a scrutiny of return that is being done, that is the 3B data is being taken. What is the outer supply in my 3B reported by me? What is the outer supply reported in GST tier 1? And what is the outer supply reported in my books of accounts? And this entire reconciliation is also provided by me, my lords, through a GST and 9C form, which is a reconciliation statement. And that is a compulsory mandatory document that I have to furnish and I furnish. So all these three documents are available with the authorities, my lord. Therefore, this is a pure case of scrutiny of return, nothing more than that. And as my lord has just now cited about armor security judgment, in page 61, para 9.2, if I may take my lord to armor security. Page number 61. Armor security. Page 61.
Page 61 of the notice. Page 61 of what?
Of the judgment.
Where is that?
Para 96.
Para 96.
2.
Para 96.
Page 61.
Para 96. Yes.
Any action arising from the audit of account or detailed scrutiny of returns must be initiated by the tax administration to which the taxpayer is.
So you say that the tax administration is central tax.
Yes, sir. And therefore, there is no jurisdiction for state tax to carry out a scrutiny of returns. That is my first argument. You supported the order. My second argument, my lord, is that in the same chauffeur notice, my lord, page 48, my lord, the order is completely perverse. And why do I say so?
And how do you say that you are only under the central administration?
Sir, because the detailed audit has been carried out by the central administration. And I'm also assigned to the central authority.
Where do I get that?
My lord, we have affixed the audit show cause notice issued by the central tax.
No, that
page
you.
74.
It's 74.
Is the order and 64 is the show cause notice. My lord, in page 64, it's clearly mentioned that I'm within the jurisdiction of the central tax. Page 64. And falling within the jurisdiction of range, Balrughat, Raigad Division, Shiliguri State Commissionerate are engaged in.
No, but the GST commissionerate will be common, isn't it, for state and
No, the jurisdiction will be assigned to a particular jurisdiction, either the central tax authority or the state tax.
who will decide this?
Well, it's decided by the GST
Council.
authority while allocating the jurisdiction. And in the case of initial registration, it was allocated on a particular percentage.
And now by the council, council decides, who decides?
No, my lord, GSTN.
GST?
GSTN.
GSTN.
GST network. Goods and service tax network, they are the person basically who decide that would be allocated to.
No, the GST network is manned or chaired by whom? Somebody must be there. It can't be a system.
No, GSTN is the body, my lord.
So the body is presided over by whom? Somebody must be presiding it. I mean, presiding over it.
It's presided by the CEO, and it's a public limited company, my lord. Different reform. They are doing it directly.
Very good.
So administratively, I am under the CGST operations. And whatever I could demonstrate through a laws, that is purely scrutiny of returns. This is the first thing, and armor security paradigm says that scrutiny of returns can be carried out only by the jurisdiction. My second ground is that the order, is completely powerless, my lord.
So, according to you, scrutiny cannot be done by anybody else apart from the
jurisdictional authority. And my second line of argument is that the order is powerless. And further, I request the Lord to page 48, my lord.
Page 48 is the show cause notice.
Yes, so there it's a matter I will speak. My lord, if you see the difference that has been brought, that as per CB dispatch, as per books of accounts, 21,86, 52, 093. Actual turnover is taken from the books of accounts. And then he's taken out the difference, which is 12,04, 28, 1.
Yes.
If you see the CGST, my lord, the figure is more than the quantum of the difference. It is 15, 71, 58, 817. Whereas as per the GST framework, this is never possible. How can the tax be, whereas it has to be 50% equally with SGST and GST? How can it be more than the taxable turnover? On these two grounds, I would request for a question.
Yes, Mr. Chakravarti. Food for thought.
Can come to order of
Page 40. Order of adjudication was passed prior to the show cause. Yes, tell me. No, what is your answer to the jurisdictional issue?
Has received that there was a separation of outward allegation. This is an enforcement. This is not the I have seen there was a seizure. On that, I have found there was a suppression. That's why this is an enforcement action. Whereas 74 is an exponent, I have not found this definition of it. Subject to correction, but I have not found the definition of it. So, what is?
But this was not based on scrutiny action.
But that is when you got the suppression of facts. But the examination of the seized documents with respect to the returns filed.
But he says that the documents that you have referred to are not required to be seized. They are already there with you.
There was suppression of outward supply. But on seeing the perusal of the document, I found there was a suppression. There was a suppression. We want to question this if a case of 74 has come. And how?
What was seized? If GSTR 1, 3B, all these are there. They are already available on the portal.
That extent I have to take question is
because no, I also want to understand this upon examination of seized records with respect to returns. Now, the returns are something which is already there on the portal. They are not required to be seized because that is in domain. Not required to be seized. So what else was there which made you arrive at this conclusion apart from this? Because the description only shows GSTR 3B, GSTR. What about the books of accounts?
Books of accounts are also furnished along with GSTR 9C1. It's a compulsory requirement.
Actual, the column actual turnover and corresponding tax liability that ought to be reported. Is maximum at the above difference between actual turnover and corresponding tax rate that ought to be reported. And
Actual turnover will be in the books of accounts only.
That is the difference. They have to maintain the particular rate. That is section 35.
But my lord, go to page 52. I've already reported this in the DCL line. This is also reported by.
Because this also will be reflected from the. Please come with instructions because this way.
Kindly consider this. But what is the enforcement action? I have seen this line scrutiny, but what is the enforcement action? Because if there is a suppression of facts, if it ventures into the issue of fraud, suppression of facts, which is takes into consideration of section 74, then enforcement. Because if violation says it's a matter, subject matter, just jurisdiction. That is absolutely different. But in a privacy case, whether the subject matter, because the subject matter can be said to be outside the jurisdiction, absolutely lack of jurisdiction. That is the language. There are two things: when the state of execution, I take the inherent lack of jurisdiction and fraud. Two things I can take at any stage. But here the question is here, whether section 74 can be considered as enforcement action. That is the first and fundamental.
74, yes. Why it cannot be? It can be, but his contention is that this has been given a show of an enforcement action while it is actually a scrutiny action. This is what his contention is. His contention is that just to give it a show of a enforcement action so that you can assume jurisdiction which you actually don't have, you have actually scrutinized the records and you have come to a finding that this is something which falls under the purview of section 74 and you have issued the notice.
But I'll come back.
About the tax amount that has been determined in the CPS, more than the taxable value. That itself shows that this is an order which is rushed in a hurry. Because my taxable amount cannot never be.
And what did you reply to the show cause notice?
We don't require.
Why you are confident that you will come and get it? 19. Yes, yes, 19.
Hello, 19 is on a different. So here it's interesting. Colors is an interesting matter. Colors, I must get a lot of cigarettes. And for selling cigarettes, I have to pay GST. Along with that, I also have to pay cess, which is a rate-based cess. Along with that, there is a concept of additional cess, which I have to pay on a fixed quantum based on the size of the cigarette. So, when I have discharged my taxes alone, I have properly paid my outward tax towards CGST, SGST. I have properly discharged my tax towards the cess. But as far as the additional cess is concerned, my lord, as far as the additional cess is concerned, that I have not reported my output tax, and I have also not availed the credit. But since both the amounts are based on the quantum, so there is no loss to the revenue. That is my first argument. And this is a matter arising out of audit. In the audit, my lord has already gone through the definition of audit number of times. I was present in the report and see. So audit is a detailed examination of records. But here, if my lord sees, the Chopin note has been derived from the GSTR 93 filed by me, where I have myself reported that this is the output tax as per my books, this is the turnover as per my return, this is the difference, this is the tax payable by me. And I also discharged the tax much prior to the date of the audit, which effectively shows that 74 cannot be invoked by me on me. And third argument by me, my lord, that section 65.
Third argument, first argument, second argument.
No, first is that it's a revenue neutral transaction.
So you did not make that argument. Now you are saying that.
Yes. That is fine. So my first argument is that, my lord, it's the main next of demand.
You thought of making it, but you did not make it, so you.
So that is my first argument, that, my lord, the main demand which is lying here.
So its revenue neutral is one.
Yes, my lord. That is my first argument.
Second is it is based on your own.
The submission made by me, my lord, and that's also incorporated in the particular audit report in the show cause notice also, that these are finding from GSTR 9C that these are amount payable, and also the fact that they already discharged it through DRC 03 much prior to the date of the audit. So that's the 74 is not true. My third argument, my lord, is that there is a clear violation of section 65(4). If my lord 65, section 65 casts duty on the audit that they have to conclude the audit within time.
Barred by limitation.
Yes, sir.
65(4). 3 months.
Yes, sir.
But it is extendable.
It is extendable up to a certain time, provided when the commissioner is provided when the commissioner is satisfied that audit in respect to the
That they have extended maybe.
for the reasons to be recorded by a further period not exceeding 6 months. So the total period that I'm getting is 9 months. But in my case,
It's beyond that also.
beyond. So these are the three main arguments. The fourth argument is that as per rule 142, I'm supposed to be served a DRC 01 along with the show cause notice. So the DRC 01 was also not served. So these are the key.
Show cause notice was not served on you.
DRC 01 was not served on me, my lord. Only the show cause notice was served. So that is one secondary argument that I'm taking. But these four arguments are clearly there.
Mr. Chakraborty, you are there.
Yes, sir.
Mr. Dev, yes.
So what this is concerned, that DRC 01 was served or not for that I have to take instruction. And
So we'll come back. We'll come back after recess.
yes, sir.
We'll come back after recess. Yes, Mr. बस, बस.
They could have challenged the show for the initial phase, but then since the stage, but they choose not to file a challenge to the show for the initial stage. They submit to the jurisdiction, they file a reply. Thereafter, when this order in constitution has been passed, they have preferred this jurisdiction. This is an appealable order. They can take up all these points for agitation before the appellate. And also, they have to demonstrate before this order court as to why the order is valid. If they have to prefer this repetition instead of filing a federal hierarchy, but which in my humble submission they have not done so. And if you also can comes to the conclusion of the appellate authority, it has been clearly given with giving all the reasons as to why the appellate authority and based on what the appellate authority has come to conclusion, which will be appellate from page 96 to 90.
Mr. Dasgupta, what is the jurisdictional ground? Because you want this order in original to be interfered with at the appellate stage, right? At the by way of a writ petition.
Yes, sir.
So you have to show that there is a jurisdictional issue involved, which can allow your client to obviate the appellate remedy and approach the writ court.
First ground that I've already taken is for section 30. The audit, if I may take my loss to the definition of audit, it entails an examination of records.
How can you say that this has been done without examining the records?
Because they have relied on the same documents which have been submitted by me.
No, so that itself, that is also a record.
But that is already declared by me in JSTR 9. So what would be the reason because we are invoking 74 on my laws? Something that I've already expressed, I've already declared before the authority.
So there is no suppression on your
There is
part.
no suppression, my lord.
How do you respond to that, Mr. De? He says that if you have not relied on something which he has not disclosed, then you cannot hold him liable for suppression, because you are saying that you have disclosed it. You are relying on whatever he has disclosed. If whatever he has disclosed is being relied on, there can be no charge of suppression being leveled against him.
To that, my lord, my answer is at page 96. Finding that page 96.
Page 96. Yes.
That is in middle portion, the paragraph starts with based on.
Yes. Based on scrutiny.
Based on the scrutiny of GSTR 3 returns and credit ledger, financial year 2020-21, I find that years 03 challan serial number 182 are valid under section 16(5) of the CGST Act 2017 as the input tax rate is availed and utilized falls within the permissible time frame preceding the cutoff date of November 30, 2021. However, as discussed earlier, payment made by the taxpayer in the aid of CGST and SGST cannot be treated as valid payment as the taxpayer has availed equivalent excess input tax credit in their GSTR 3 in comparison to their GSTR 2A. Hence, only payment of sales amounting to Rs 10,59,000 paid for 59,69,990 is treated as valid payment. Out of total payment made by the taxpayer to input tax credit of Rs 10 crore 65,76,618 to BRC 03 challan dated 12/21. However, it is evident that the taxpayer knowingly suppressed taxable outward sales to evade tax liability as observed from their GSTR 9C and
Yes, Mr. Dasgupta. Last 4 lines.
Yes. And another thing I will have to show you, that is the findings at page 95. The paragraph starting with on examination, your can comes to the last 3 or 4 lines of that paragraph.
However, it is evident.
However, it is evident that initially the taxpayer suppressed taxable outward sales to evade the tax liability and make this payment upon issuance of audit observation. Thus, they are liable to pay the interest under section 50 of CGST Act 2017 and penalty under section 74 of the CGST Act 2017, section 11 of the Goods and Service Tax Act. Now, Lordship, read with this the observations made at page 98, para 5.8. findings.
Yes.
Para 5.8. From the above para, I find that the allegation made in the show cause notice is sustainable. However, upon introduction of provision of section 16(5) of the CGST Act 2017, the payment of sales made by the taxpayer through DRC 03 are converted admissible in value. Hence, at this stage, only amount which was charged and collected by the taxpayer but not deposited to the permitted staker is to be recovered from them. It is also seen that the taxpayer willfully defaulted on its obligation to remit the additional sales he had collected, resulting in an outstanding liability. This act of willful suppression of material facts.
So, Mr. Dasgupta, this is not a clear case of loss of jurisdiction. Next point.
My lord, if you see the particular point, in this particular point on page 98, my lord, on this he is clearly saying, I find that the allegation made in the SPN is sustainable. However, upon induction of provision of section 15(5) PGST Act, the payment of cess made by the taxpayer to DRC 03 are considered admissible. My lord, when there is a change in the law, when my tax has been considered to be admissible, can the penalty stand, my lord? That's my question that I'm asking myself. By operation of section 55, which is amended and inserted in the law, which says that any ITC which are prevailed till 30th November 2021, I am eligible to take the ITC. So, my lord, if I am eligible to take the ITC, can interest and penalty burden of the same arise on me, my lord? That's my precise question first. So that's why I would say that the writ court has the jurisdiction to consider this particular matter. That is the first ground.
What does section 65 say?
16(5).
16.5. Ah, I got it. Yes, yes. Mr. Kanodia had once made me go through it. 16.5.
Yes, sir. 16(5).
I have an outdated book. In 5. Yes.
Yes, sir. So, notwithstanding anything containing subsection 4.
If it is filed up to the 30th day of November 2021, which you did.
Yes, sir. And that is also accepted by the adjudicating authority.
So, Mr. Dev, this is the case.
These have been considered. Yes,
because,
my lord, these are the basic contentions we have made in the show cause notice.
So this goes.
This goes. Now, Lordship kindly comes to case 66(1). If they were really agreed by this contention of the department, they could have challenged it at the show cause issuance stage itself, which they have not done. Now, adjudication has been done. Now, the entry open to them is a irregular appeal. Because if the Lordship kindly comes to page 66, para A2, it has been clearly stated as to one of the reasons for issuance of the show cause.
And what about page 95?
Yes, well, they have counted that point, my lord. If this matter is accepted, then why on page 99 is the penalty raised on the entire findings? My lord, on page 99, the adjudicating authority imposes a penalty of 19 crores 15 lakhs on the entire debt that are supposed to pay. She is admitted that I already discharged 10 crores.
That the appellate authority can take.
At best, a arithmetical.
That the appellate authority will do. Why writ court will do that? Mr. Dasgupta, a particular portion of the entire claim ought to have been slashed off.
Yes,
by reason thereof, interest and penalty payable to the extent that portion is concerned, that also would have been knocked off.
Yes,
that has not been done.
Yes.
That can be done by the appellate authority, for which writ court will have to intervene. It is jurisdictional error.
First ground for interference, my lord, because they have invoked 74.
That is a ground for interference, very good for the appellate authority, not for approaching writ court. Why should the appellate remedy be? It is an arithmetical error, an error within jurisdiction. That is corrigible in appeal.
No, no, it's not an arithmetical error. It's an error of jurisdiction. It's an error of principle because she has dropped the deed tax.
But that is arithmetical. She has dropped the tax at one point, at one place. So that is again an error of jurisdiction. That error within jurisdiction. You have wrongly calculated it. You ought not to have calculated when you have dropped. This point can be taken care of by the appellate authority. You will come here before the writ court bypassing the appellate remedy only if you can say that the error is of jurisdiction in such manner that the authority could not have done it at all.
Yes, sir.
So it is only a portion of it.
Yes. And one point, seriously, then I'll go to the next point.
No, what he has said that he has indicated at page 95 that this is the manner in which you have suppressed. This is how they have arrived at a finding.
No, well, that is my basic thing. So whatever suppression is being told, they have taken the figure exactly from my lines. That is
The difference now.
Because a learned senior was just taking us to page 66. If you go to page 66,
Page 66, he was going to show that it matches with the show cause notice. There was an allegation in the show cause. That was what he was driving at.
Yes, sir.
Now, if you see page 95,
Yes.
page 95 says that you have suppressed the taxable outward sales to evade tax liability, and you made payment only upon issuance of audit observation. So, if audit observation had not come forth, then in that case you would not have made the payment. That is the premise. If that is the case, then there is an element of suppression. What is wrong in this observation?
The payments have been made much prior to the date of audit, my lords. I made the payment much prior to the date of audit because I made the payment before 30th November 2021.
And when did the audit?
2022, my lords.
Then, Mr. Day, how does this stand then? How can he be wrong on all counts, Mr. Day?
On the report, also can you see the dates of the DRC03s are all mentioned, which is at page 95.
Page 95, yes.
In the middle portion. Now we have Dr. Kelly comes to almost the middle portion of,
Yes.
of the first paragraph. 5 numbers of DRC03 are dated 13/3/20, 8/7/20, 23/9/20, and 26/4/22, and 19/5/20.
Yes.
So these are beyond the dates of
The audit observation came when?
audit observation came on 20th May 2021.
20th May 2022. And you made your payments when?
I made my payments on 13th of March 2020, 8th July 2020, 23rd July 2020, 26th April 2022, and
Oh, that is what he just now showed. This taxpayer made it through input tax and aforementioned fine you challenge it is such and such and such.
and the show cause notice is issued on
So this is evidently wrong, Mr. Day.
Or we will take in that case a clarification.
When can you come back?
It's so scheduled.
Let him come back after 10 days. Why? State has nothing to do. It will help you.
But my lord, as I say, my lord.
No, I have no problem. I'm coming every day. You will come one day, not. এই বইটা দিয়ে দিন এটা রয়ে গেছে থ্যাংক ইউ Oh, that matter, yes.
Chart indicating the page numbers of the respective regulations.
Mr. Chakraborty, then I'm sending it back to the adjudicating authority, proper officer, because 75(7) is in breach.
You on the merits
No, the order will go. If the order goes, he will start afresh. He will not be influenced by whatever is. Of course, if he cannot be influenced by a set aside order.
But the lower authorities what they
No.
do, in the fresh proceeding, they take material from that order. This towering presence. When he comes with every point, he has 50 flash.
এটা লিখে নিন। Which are now being conducted in terms of this order will not be questioned on the ground of limitation unless you could have questioned it at the time when the initial show cause notice was issued. That is it. Because this
Why I say no? Because first 3 years, 128 days still I can. So if there is some demand which is confirmed against me, I can just pay that and.
so that is if you could have if you could have challenged the show cause notice at the time, then I'm not closing that. But because the order has been set aside, that cannot boomerang on that, saying that no, it will not be to their detriment. Correct.
6% shall thenceforth be liable to pay central tax at 6% on all services of DPA supplied by it. So the supply made by you under RCM from 10th April to 31st March is treated as taxable as 6%. So they have changed the
Supreme Court.
My lords, I'm appearing in item 1, but the court is not audible. I know.
There is a division bench judgment, Mr. Bhattacharya.
I've located that, my lords. There is a judgment in the case of Alan K, which says that the outside notary's affidavit can be accepted. And even the rule 16, chapter 15 also says so, my lords. I've read that also.
But Mr. Dey, if the address is of Calcutta, why did he not come? Why he has? But this is also not. This is. So you withdraw and file afresh. Unnecessarily, this will create problems.
My lords, I'll explain that thing if my lords permit me. I'll explain that thing.
What did you say, sir?
My lords, actually, he's an employee of Reckitt Benckiser. Reckitt
Whatever it
Benckiser
is,
has
he
an
has
off.
given his address. He has given his address of Calcutta, and then he is getting it notarized from Delhi. It doesn't appear proper. It's inconsistent with whatever he has stated.
My lords, what I can, my lords, though there is a judgment from this honorable court of Alan K, wherein
That is
such
there, but that judgment was in the context of a person who was not residing here. He has given his address here. I would have understood if he had given the address of Delhi. He has written his address of Calcutta and he is getting it notarized at Delhi. How?
my lords, that is because of the company address he has given. That was the mistake.
He
That
has
can
given
be.
his address as residing at flat such and such in Kolkata, sir. Please look at the papers. Please see page 39.
Yes, my lords. We can refile the affidavit, my lords. If
The
my lords permit me
refiling
to
the
do that.
affidavit won't do. You will have to withdraw, file a fresh writ petition on the same cause of action.
My lords, this is just a technical brief.
You take instructions, file it on record so that I can permit you to withdraw. I'm making it not today. Bring your instruction tomorrow. Not today. No, I don't know. Hold on.
My lords, can I request one thing? Because
it could
this
have
is just
been
a
done in
technical.
one shot, but because of this technical objection which he has taken, he is entitled to take.
Not saying that by way of notary public cannot be done, but you cannot say that notary public within the 5 kilometer radius of the Calcutta High Court. It cannot. It's not saying that the notary public cannot be filed, but within the 5 kilometer radius of
Very well. Withdraw it, file afresh, because all these technical objections, you will get an order and then it will be set aside on the technical ground. What is the use?
Item number 2.
Separate. Huh? No, 2. Yes, but they will be argued differently. Different sets are there. Why not appeal? And that was not given.
regulation says can go up to 100% or up to 500%. Cannot be same for E or B. If you have said that I am an appraiser or I am an assistant, you cannot fix my liability or quantum of issue to the extent of say to the primary who is benefiting from the that. So this is my second round of argument. If I cannot succeed in the first time, I will go to this. Then what is my view? Why you are imposing 18 crore? It is for the executive authority to justify because it talks about his jurisdiction. Not crossing the highest limit does not mean his activity. There is a law limit. He could have imposed the 1 rupee. But why he has imposed me 18 crore? That he is to justify. That is also a point of view. So when if I succeed in first, I won't take your lordship for a second. Where can
Sure.
we come to? My decline first.
Page
Page 134. When you come to 134,
134. Yes.
before that, I hear 107. You cannot say that this is my purpose.
107.
107. That he has depicted my statement. I am not going to the whole. Kindly come to Roman 11. On being confronted with the statement that such and such and such and such, actually avoid what Shamana literally marked them. Wherein he has revealed as a key member of the city, involved in the illegal report of Netherlands. He refuted the allegation made by the Robert for child. So I refuted allegation. He also stated that he is not aware about any examination or seizure of data ever done by PRA Kolkata belonging to state, high court concerned or city export or expedia. On which only for the honor of the court and we shall continue. He denied of the so this was my stand during the speech. Now can you come to 125? This is my reply to show 125. 134 it starts. 134. It is internal part of the improved order where the adjudicating authority records my
134.
134 it starts.
Yes.
Kindly see figure number 2. Most of the states and the allegations brought to the state against any arbitrary and without any deceit and has not related to stand. There is nothing on record for us to put the issue number 7. If in any illegal act, in any way, or he is concerned involved in any illegal act, save and except voluntary statements of one person or one child. Then kindly turn to 135, kindly come to serial number 7. The improved estate appears to rely heavily on oral statements only rather than on tangible physical evidence. After section 108 of customs states while statements made during investigation are admissible, they must be corroborated by material evidence. Allegations based purely on statements without supporting documents or physical evidence cannot form the basis of the enforcement of any action. Statements must be subjected to rigorous scrutiny and examination in terms of 138B of the customer, especially when they are made under duress or in circumstances that might affect their credit. By indicated that 138B has to be complied. Then 9. Any statement made next statement is liable to be examined in terms of 138B of the customer. Then can come to paragraph 8. Impute show-cause is found to be based on the statement of our Jack over 5. And that is why he needs to be cross-examined for establishing the fact as per section 138B of the customs act. And I have referred to
several judicial. Where I stop. Here my point is that. Now kindly come to page 149. Finding against me.
Page 149.
149. The finding actually starts from page, finding starts from page 145. 145 of the finding starts. So far, 3 is concerned.
149.
Respect to say Ashish. When I find, despite being summoned twice, asking the page to appear and instead short interim bail from the court. That this is my offense. I have short interim bail. Which was clear. He only appeared after the third scene. I appeared. His non-appearance on first location clearly shows deliberate attempt to avoid issue. Then no one to is involved. I find that Ashish Munda reportedly a part of syndicate involved in smuggling material as part of what Kumar does statement under the subject to correction. The following part, subsequent part, all are related to statement of our Kumar. Not a single thing other than our Kumar just on that basis. Now can we come to page 153. And the last person to be imposed with 2 penalties under 2 different sections, 9 crores and 9 crores. I'm saying this. Penalty. And I'm relying on certain judgments. When I am told that the compilation has been provided. Reading out because in the top index page I have indicated judgment of each judgment I have divided out 11 judgments, including honorable Supreme Court, honorable division bench of this honorable court, honorable single bench of this honorable court, all are of the identical point. The point is 2 law points. Number 1, cross-examination evidence given. You cannot rely on any statement. In fact, in the judgment quoted at serial number 9 by the honorable division bench of this court, say, remanded the matter with the direction that if you want to rely on any statement, you will give opportunity of cross-examination. Otherwise, you will not rely. That was the direction. So, and the other question of law point is that 138B is a mandatory provision which has to be complied with. Unless it is complied with, no statement has any relevancy in the eye of law, even in a prosecution. But this is the position of law. I have indicated all the relevant paragraphs, and I have taken to your lordship that this order so far I am concerned. Who are me? I am not about anyone. Who are me? Should be washed and saying that in the light of the judgment class, if they want to rely on this statement, they will give the opportunity. Otherwise, they will. That is my.
Yes, Mr. Kundali.
And I have not opened my mouth of facts. My dynamic brain is on a simple question of law. And I have showed my points in 3 pages only. I expected to be answered that without trying to prevent court.
Basic facts that without going into that, whether that cross-examination is required or not, that depends on the identification of the.
That was what they actually
I got the
Let him continue. Yes, Mr. Kundali.
That is that without looking into that, my lord will not be able to come to a conclusion how whether it is. This is at least this identification on a CBT of working regularly and in this particular case, this CBT and the right of good powder, they were
learned friend, the way you are like 89, thereafter. So I would like to come to page 1. I learned friend,
149.
Roman 3. Thereafter, from Roman 2, further I find that existence
150.
I reserve my right to countervene justice judgment, but before that, factual part, whether right or wrong, fine. I will finally see 4. Further, I find these are the findings against Mundra. Further, I find that the investigation that Ashish Mundra had knowledge of the illegal import of 1,07,000 facilitated by Sri Vishal Pandit to Messrs. I-Paul Consultant Private. Now, Vishal Pandit is the next part. I further find that the noticing has sought from the examination of the person whose statement has been relied upon to implicate present notice. I also find that though notice has sought from the examination, but he did not elaborate the fact with which he did not agree. There is a finding that he did not control or elaborate the information. I also fail to find that what any new facts emerge out to the prosecution. Hence, I find that the only intention of the notice seek cross-examination is to drag the proceeding. Further, I find, in view of the several judicial pronouncements, that cross-examination cannot be sought as a matter of right. I rely on the observations made by higher authorities. And several cases have been. So he is asking for the cross-examination of a pornography. Because of pornography, it's also a pornography. Now I got this perspective. I got kind of this one. I'm not going to be judged as my different as possible. After judgment also. I will rely on one judgment which may have a very immediate clear. I will tell you page 151.
Yes.
In the present case, 2. The findings in the above line have been arrived for not only on the basis of statement, but also on the basis of other evidences such as seizure of grocery is declared. In view of the above, I find Mundra with act of commission and commission section to illegal import has committed an offence 112A and 112. What I will kindly also come to, I will try and come back to the other page that my learned friend has shown 107. My learned friend showed 107, 11. What I will try and see 12. Last paragraph, we asked, allow we not there. On being confronted the statements of 9, 11, 10, 12, of the other where he was given he refuted the allegation made by the other. My learned friend has already faced this paragraph. He also stated that he is not aware of any examination of
ever done by TRI belonging to the said ICOL consultants or as a Shruti Exports or SPKT on being shown the photo of Rohit Kumar Jha and Vishal Pandey, he denied from doing that. Now, my lord, this is pertinent. On being asked about whether summons under section 108 of the Customs Act had been issued against him in the past, he admitted that he had tendered his statements in 2024 in course of an investigation conducted by TRI, which is related to case of import of Middle. And in that case, he happened to be a buyer of an allegedly improper import of Middle. He had also been made a case for the of board booked by TRI. One of their statements dated 10th November 20, Rohit Kumar Jha stated that he had been known to Ashish Mundra from January 2023 through one of his friends, Tanmay Bose. Statement of said Tanmay Bose was recorded on 28 May 24 under section 108. This statement said Tanmay Bose should have ever included Ashish Mundra Jha. A follow-up inquiry based on customer application form of mobile number dated number student used by Ashish Mundra was carried out. A follow-up inquiry report dated regarding that Purana. See, so and so, who named the mobile number, so and so used by Mundra actually registered or from the statement of Sri Kranti Purana was recorded under 108 of 1960, where he admitted that he had taken the fancy mobile, the same number, name about 10 years ago, and gave it to Sri Ashish Mundra for monetary consideration of his 5,000 and as he to his younger brother Sri Abhishek Mundra. He further admitted that he had no business with Ashish Mundra or his brother Sri Abhishek Mundra. On being confronted with the statement by Rohit Kumar Jha, he stated that he did not know is Ashish Mundra and Sri Rohit Kumar Jha. He pleaded ignorance. So, Ashish Mundra was using a phone. The statement is given by the person who has the owner of the SIM card. Then this has been being used by Ashish Mundra for the past 10 years. Now,
Up to you. I am here. I am here. I have no problem. It's up to you to decide. Tomorrow?
I'll